Good morning, ladies and gentlemen. The Subcommittee on Courts, Intellectual Property, and the Internet will come to order. Without objection, the Chair is authorized to declare recess of the subcommittee at any time. We welcome all our witnesses today. We will now have our opening statements. This morning, the subcommittee will continue its review of our nation's copyright laws by hearing testimony concerning what is within the scope of copyright protection. Our witnesses will present contrasting views on three important copyright issues: the making available right, A, should broadcast be protected with additional laws, B, and C, how laws, codes, and standards be protected under the copyright law. I and others have worked to bolster our copyright laws and protect local broadcasters whenever possible. And I've also advocated that these efforts be generously laced with common sense. Common sense, it seems, is an ingredient that is sorely missing sometimes on Capitol Hill. And I guess all of us are guilty of that. Maintaining these philosophies has become complicated by evolving technology, and hopefully our witnesses today will highlight the most important issues confronting our copyright laws. Piracy and online infringement are an enormous concern, and we have repeatedly heard testimony over the past decade about the harms caused by file sharing. It was disturbing to hear that judges were uncertain at times of how to respond to this crisis. I'm pleased to learn that one of our witnesses, Mr. Nimmer, has updated his copyright treatise and made it perfectly clear that making available copyrighted works for others is infringement. That being said, I do not want to steal the thunder from this morning's testimony, but I encourage all members, especially those who have not focused on these issues in the past, to carefully consider today's testimony. In closing, I thank our esteemed panel of witnesses for participating in the hearing today and look forward to your remarks. I'm now pleased to recognize the distinguished gentleman from Michigan. By the way, John, this is our first meeting since Mel Watt left us.
Yes.
So for the first time in years, there will not be a North Carolinian on this side of the judiciary aisle, but I hope we'll survive. Good to have you, John.
Thank you, and good morning to the chairman and the members of the committee, and the very small number of witnesses that we have before us this morning for a very important subject. The hearing today provides an important opportunity for us to consider various provisions of copyright law and to examine whether the laws continue to adequately protect creators and promote innovation in light of developing technologies that were not contemplated when these provisions were originally enacted. And to that end, there are several factors that we should keep in mind. For example, the making available right, which gives copyright owners the exclusive right to authorize the manner and terms to make their content available to the public. I favor strong copyright protection because it benefits creators and promotes innovation and economic growth. Strong copyright protection laws also helps create a marketplace for content that viewers will enjoy, as well as the latest technology that can be used to watch the content. The making available right is especially important today, where one copy of a work over the internet without authorization could provide access to millions of users around the world. The making available right helps prevent infringing conduct. For those reasons, we do not need to change copyright law for the making available right. Existing law already includes a making available right. I don't believe that there's any ambiguity in the law, and some federal appellate courts have recognized the making available right. In addition, the United States is a party to various international agreements that require signatories to implement the making available right. Congress has repeatedly demonstrated by ratifying these agreements that the United States law already includes this right and no change is necessary. In any case, as we study this issue, we should consider guidance from the Copyright Office, and to that end, our former colleague and ranking member of this Subcommittee, Mel Watt, sent a letter to that agency last month asking it to study the current state of the making available right and to make recommendations. In particular, we need to know how American consumers fare under current law in the context of digital on-demand transmissions such as peer-to-peer networks, streaming services, and music downloads. Additionally, we need to know how the competitiveness of U.S. technologies can be strengthened in the global marketplace under international treaties to preserve robust protection for creators. In conjunction with the testimony we received today, this report should provide us with valuable guidance. Second, the evolution of technology has had a major impact on the debate about copyright protection for broadcasts and has generated many unresolved legal issues. Just last Friday, the Supreme Court granted certiorari in a case where the nation's largest television broadcasters have brought suit against Irell, a streaming video service. This decision could have a wide-ranging impact on internet streaming, cloud computing, and the television industry. Whatever the outcome of this case, I believe the law must avoid any anti-consumer ramifications, including higher fees and restricted access. To be clear, moving forward in this copyright review, we must ensure that creators are protected. Strong protection for creators will ensure that consumers continue to enjoy the works that define our culture and enrich our lives. And accordingly, I thank the chair for his leadership on these issues and look forward to further collaboration on them. I thank you.
I thank the gentleman. I now recognize the distinguished gentleman from Virginia, the chairman of the full committee, Mr. Goodlatte, for an opening statement.
Well, thank you, Mr. Chairman. I appreciate your holding this hearing, and I want to welcome all of our witnesses and this capacity crowd in the audience to a hearing on a topic that goes to the heart of copyright law. What is the scope of copyright protection? The committee will hear testimony on three related issues. The first issue, concerning a making available right, seemed to be settled by the U.S. accession to two separate WIPO treaties in 1988. However, uncertainty has arisen in several file-sharing cases, and most recently in a library case in the 10th Circuit, in which the opinion was released only 3 weeks ago. I look forward to the thoughts of Professors Nimmer and Lunney on prior jurisprudence and whether Congress should bring greater clarity to this fundamental issue of copyright law. The second issue concerns the scope of copyright protection for broadcasts. Although the U.S. is not a party to the Rome Convention, ongoing discussions in Geneva could result in additional copyright or other protection for broadcasters in an effort to deter signal theft. Broadcasting has changed significantly since the Rome Convention was signed in 1961. Smartphones with an always-on internet connection now make everyone in this room a broadcaster in ways that were unimaginable 50 years ago. I look forward to hearing from Professor Schultz and Mr. Love on this topic. Finally, we will hear about an issue that has received less public attention than the other two, but is one that does go to the heart of how citizens interact with their government. It was also the subject of the very first copyright case heard by the Supreme Court in 1834. Copyright protection for laws, codes, and standards appears to clash with the fundamental ability of our citizens to know what laws and regulations they must live by. It is fortunate that the number of states seeking to claim copyright protection on their laws and regulations, despite long-standing Copyright Office and administration views to the contrary, has sharply declined. However, the issue of copyright protection for codes and standards incorporated within them is more nuanced. Recognizing that codes and standards are developed at some expense by private sector entities, I look forward to hearing from a representative of the American National Standards Institute and an individual who has made greater access to government information, including the videos of congressional hearings like these, his long-standing mission. Before I conclude my opening remarks, let me turn to a few other issues not being heard today. I'm sure that there is no one in this hearing room who isn't aware that the Supreme Court announced on Friday that it will hear oral arguments later this spring in the Irell case regarding another issue related to the scope of copyright, the public performance right. The Court also announced Friday that it will hear oral arguments in 2 cases with implications for the patent troll issue, something this committee and the House has already addressed. These 3 intellectual property cases are in addition to earlier patent cases taken up only a few months ago by the justices. It is hard for me not to notice that once again this committee continues to lead the way on critical policy issues. I want to thank the witnesses again for their time here today and for their flexibility in their schedules to enable them to be here. Thank you, Mr. Chairman.
Thank you, Chairman Goodlatte. We have a very distinguished panel today, and I will begin by swearing our witnesses in before introducing them. If you would, please stand and raise your right hand, if you will. And do you swear the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. The records show that all responded in the affirmative.
Mr. Chairman?
Yes.
In order to have this in the record at the time of the hearing, could I ask unanimous consent to put documents in the record at this time so they can be copied for the members?
Without objection.
Thank you. Do you want to hear them all, or just you'll take all of them?
We'll take all of them.
Thank you very much.
Without objection.
Thank you.
Thank you, witnesses. I'll introduce the witnesses. Chairman Goodlatte mentioned the standing room only crowd, and this shows me that you all have more than a casual interest in this very significant issue, and we're pleased to have all of you with us today. Our first witness today is Mr. David Nimmer, a professor at the UCLA School of Law and an attorney in private practice with the law firm of Irell and Manella. In addition to his numerous books and articles on United States and international copyright law, Mr. Nimmer has updated and revised releases 19 through 92 for Nimmer on copyright. He received his J.D. from the Yale School of Law and his A.B. with distinction and honors from Stafford University. Our second witness is Mr. Glynn Lunney, Jr., a professor at Tulane University School of Law, where he teaches courses in intellectual property, unfair competition, and contracts. Professor Lunney earned his J.D. from Stafford School of Law and his B.F. from Texas A&M University. He also earned his M.A. and Ph.D. in economics from Tulane University while teaching at the law school. Our third witness today is Mr. Mark Schultz, professor of law at Southern Illinois University of Law and senior scholar at the Center for the Protection of the Intellectual Property at George Mason University School of Law. Professor Schultz received both his J.D. with honors and B.A. in International Economics at George Washington University. Professor, is that the Salukis? Is that the name? That's the name most folks without any connection with the university know the nickname. Was it a dog?
It's an Egyptian racing dog, yes, sir.
All right, thank you. Are you awarding me special credit for knowing that? I'll accept it. Good to have you with us, Mr. Schultz. Our fourth witness is Mr. James Love, Director of Knowledge, Ecology International. Mr. Love earned a Master's in Public Administration from Harvard University, the Kennedy School of Government, and a Master's in Public Affairs from Princeton University, Woodrow Wilson School of Public and International Affairs. Our fifth witness today is Ms. Patricia Griffin, Vice President and President Counsel of the American National Standards Institute. Ms. Griffin joined ANSI in 2004 after 20 years of private practice, and she earned her J.D. from the Albany Law School and her B.A. from Skidmore College. Our sixth and final witness is Mr. Carl Malamud, President of Public Resource Organization. Mr. Malamud founded the nonprofit in order to work on the publication of public domain information from local, state, and federal government agencies. Mr. Malamud received his MBA degree from the Indiana University Kelley School of Business. We welcome you all, and our first witness will be Mr. Nimmer. It's good to have all of you with us. Gentlemen, lady and gentlemen, if you could confine your statements to on or about 5 minutes. there's a panel on your desk. When the green light turns to amber, the clock begins ticking, and you're about to come up on 5 minutes, which will appear when the red light illuminates. And we try to apply the 5-minute rule to ourselves as well. So during question, if you could be as courteous as possible, that would be appreciative. Mr. Nimmer, if you will kick the ball off, it's good to have all of you with us.
Thank you so much, Mr. Chairman, and thank you to all the members of the committee for the invitation to testify this morning. We gather to consider the scope of the rights that belong to copyright owners. One of those rights is public distribution. The question today is how to prove violation of that distribution right. Specifically, does the act of placing a digital file containing a copyrighted work into a file-sharing folder on the Internet violate the law? Or must the copyright owner additionally prove that a third party downloaded that particular file before the uploader can be held responsible? In short, does copyright law's distribution right include a making available component? Let us imagine that a user uploads a full copy of the motion picture Avatar to a share folder operated by a peer-to-peer service. Anyone else on the P2P network can then watch Avatar at no charge. I respectfully suggest that the better course of congressional action is to reaffirm the existence of a making available right so that the unauthorized upload itself is considered infringing. The alternative is to force the copyright owners to prove that third parties subsequently downloaded that particular copy of Avatar. That alternative unnecessarily clogs judicial procedures and threatens user privacy. As the eloquent introductions at the opening stated, it was the intent of Congress in 1976 to include a making available right, and the U.S. has joined 2 treaties that require this country to recognize that right. Unfortunately, nonetheless, there have been divided rulings on the subject from the district courts. Although there's one recent ruling from the 10th Circuit recognizing the making available right, there is still, as that court recognizes, a dissensus in the courts. For that reason, I urge Congress to reaffirm the making available right aspect of the copyright owner's distribution right. A brief history helps to frame the issue. Reverting to the mid-20th century, the Copyright Act in effect then gave owners the exclusive right to publish or vend the copyrighted work. Someone who made a work accessible to the public was therefore an infringer with no further proof needed. If we imagine a bookstore in 1950 featuring numerous copies of a bestseller stacked on a table near the front door, the case against the store owner was complete. In other words, copyright law at that time imposed no obligation to place undercover agents near the cash register to develop evidence that third-party customers actually walked out the door with copies of the book in hand. Translated to today's vernacular, copyright owners at that point enjoyed the exclusive right to make available the protected work. Of course, they could have hired investigators to stand in the corner and record every transaction, but that exercise was always considered unnecessary. It should be considered equally unnecessary today. Rather than a private eye unobtrusively watching the cash register to see who bought books, proof of downloading today is far more invasive. It requires the issuance of subpoenas to Internet service providers to identify, for example, all subscribers behind the Internet protocol addresses who downloaded Avatar on a given day. Such subpoenas are multiplied 10,000-fold. For that reason, we have seen case after case confronting procedural challenges to these types of subpoenas. The entire exercise can and should be avoided. As opposed to extensive motion practice over subpoenas or digital dragnets designed to ensnare the identity of everyone who uses a P2P service, there is a much more straightforward option. Continue copyright law on its traditional path by holding liable those who make works available to the public without the copyright owner's permission. Ideally, litigation procedures against uploaders should be streamlined. The resulting case need not delve into intricate questions of who downloaded the work on which day. Equally, it should not result in a multi-million-dollar judgment and massive trial procedures. For that reason, I recommended that Congress investigate 2 sensible adjuncts to its reaffirmation of the making available right. The first is recalibration of statutory damages to a sensible level that deters uploaders from their infringing activities, but not through the possibility of billion-dollar rewards as at present. The second is establishment of a form of small claims court to consider routine P2P cases and to award those appropriately reduced damages after liability has been established in a fair and expedited proceeding. These reforms will not solve all the problems faced by the copyright world, but they will set the law on a reasonable course designed to protect the interest of copyright owners and to safeguard user privacy interests on the Internet. Thank you very much.
Thank you, Professor Nimmer. Mr. Lunney, I talked to Mr. Schultz about the Salukis. I will admonish you because the Texas football team was not very genial bowl host in a recent Duke University Texas A&M football, but I'll hold you harmless for that. Good to have you with us, sir.
Thank you, Committee Chair. I'm terribly sorry that the Aggies were not polite to your team in the bowl game. Maybe not that sorry, but it was a good game. And if you didn't stay to the end, you missed something pretty exciting, didn't you? So I'm here, and I probably have the hardest task of the witnesses up front, because the first point I'd like to make to the committee is that file sharing may not be quite the scourge that it's been made out to be. It's not the scourge of American culture. It's not the scourge of American business. The second point I'd like to make is, even if it were, the making available right's not going to solve the problem. And the third point is, if we add the making available right using the linguistic framework we see in the WIPO treaties to our act, we're going to reopen a lot of what seem to be fairly settled issues on the Internet with respect to linking, cloud computing, social networking. These things that have been resolved under existing linguistic framework, if you add a vague right that says making available to the public, we'll have to relitigate them all over again, and I think that's a problem. Now, I know I'm sort of don't have much chance to persuade you that file sharing is not a bad thing. But for me, there's a fundamental difference between copying and stealing. Stealing is basically wrong, and we should prohibit it wherever we find it as a general rule. Copying, on the other hand, is generally a good thing. It's not just the best thing since sliced bread. We wouldn't have sliced bread without copying. We wouldn't have culture. We wouldn't have civilization. I can speak to you today, and you can understand what I'm saying, or at least I hope you can, because you and I speak the same language. We speak the same language because we are born with the intrinsic ability to hear or see what another speaks or does and imitate that. Copying is a fundamental attribute. It is what makes our civilization possible. And so when I look at file sharing, I don't see a scourge of culture. I see an invention that has put music in the hands of more Americans than any invention since the phonograph. Now, I'm told that the problem is it puts them in the hands of those Americans without them paying for it. And this is the real problem. It's a problem for the economy. Jobs are lost. It's a problem for the creation of music. People are not getting paid. Why would they remain in the business? And so when we think about those problems, for me at least, the jobs argument is reflecting a very old fallacy that economists have identified since 1850. That money is not lost. It doesn't go out of the economy. The fact that consumers don't have to pay it for music means it remains in their pocket, and they can invest it or spend it elsewhere in the economy, and the jobs are just created elsewhere in the economy. They're still American jobs, so there's no loss on the jobs front. Now, with respect to the creation of music, this goes really to the heart of copyright. Its fundamental premise for 300 years is that more copyright equals more revenue equals more works. And we have very few opportunities to test that premise, but file sharing gives us one of the few. Revenues to the music industry in particular have fallen dramatically. Now, whether all of that's due to file sharing or other factors, it's a little difficult to say. I'm perfectly willing to accept some part of it is due to file sharing, but my concern is what happened to music output. And we turn to measures of music output. By most of the measures we could use, music output seems to be remarkably healthy. And if the goal of copyright is to produce more and better works, the progress of science, then file sharing doesn't seem to be interfering with that at all. Now, maybe you don't accept my perspective on that particular issue, that file sharing is not quite the scourge it's made out to be. So let's move on to the second point, which is that making available rights is not going to enable us to solve the file sharing problem. It's not the proverbial silver bullet. The point here is basically simple. Whether you have to prove making available or you have to prove a distribution, the way you're going to do it is to download the work from the file sharing program. In the distribution context, you may have to download it to show that a distribution was made. In the making available context, you have to download the work to prove that the link really is to the work it says it is. Things on the internet are not always what they say they are. That may surprise members of the committee. So you actually have to download it to check and make sure it's the actual work. So as a practical matter, there's no real difference here. From 2003 to 2008, the music industry sent demand letters to some 35,000 Americans for engaging in file sharing. And none of those cases or instances, as far as I know, were dismissed because they could not show a download. Rather, the music industry gave up that battle because while they went after 35,000, estimates suggest there might be 35 million Americans engaged in file sharing. So it was never realistic to go after all of them. And second, these are your clients, your customers. Suing them is probably not good for business. And third, it wasn't working. So I don't think a making available right will change any of that in the file sharing context. As a business decision for the music industry, it's still not going to make sense to go after these individual file sharers. The final point I would make is that it's going to reopen a lot of what seem to be settled issues, and I think that would be unfortunate, really chill business innovation and investment in new technologies. Thank you.
Thank you, Professor Lunney. Professor Schultz.
Chairman Goodlatte, Chairman Coble, Ranking Member Conyers, and members of the subcommittee. I appreciate the chance to speak with you. Today's subject, the scope of copyright, is the right place to start a detailed review of the Copyright Act. However, the subject matter of copyright should be one of the least controversial parts of copyright because it goes to the very heart of its justification. Today I'll be speaking on my own behalf as a copyright lawyer and scholar. I'll speak first about the scope and subject matter of copyright in general, and then I will specifically address how these principles apply to protection for broadcasts. Copyright has traditionally had a broad scope, for good reason. Copyright protects the productive intellectual labor of authors, provided that those labors result in an original expressive work. It exists to provide those who create, invest in, and commercialize content the chance to enjoy the benefits of what they create through exclusive rights. When creators can benefit from their labors, the public also benefits. While many speak of striking a balance between the rights of copyright owners and the interests of the public, in truth, those interests are rarely out of balance, at least with respect to core copyright principles such as the scope and subject matter of copyright. James Madison recognized this fact in the Federalist Papers when he said of intellectual property that the public good fully coincides with the claims of individuals. The public will get the works that educate, entertain, and inspire and inform them only if their creators can obtain just compensation. In the end, creators, businesses, and the public are all best served when our intellectual property laws recognize the essential core value that those who invest labor and risk capital to create and distribute original content deserve protection of their property rights. Which brings me to the topic of legal protection for broadcasts. In the copyright and telecommunications laws, Congress created a legal framework that ensures that both creators of television programs and local broadcasters have the opportunity to be compensated for their labor, investment, and innovation. This legal framework has two purposes. The first is to prevent third parties from undermining the labor, investment, and incentives of creators and broadcasters by free riding on their labor and investment. The second purpose is to encourage high-quality, locally focused broadcast television. The laws have been a success. We have a dynamic and vibrant broadcast industry in which the rights of individuals and the public good are both promoted. Here are just a few examples. There are nearly 1,400 full-power commercial broadcast television stations in the United States. 78% of Americans get their news from local TV daily, including important emergency news. Nearly 60 million people still depend exclusively on over-the-air signals, including 30% of households with annual incomes under $30,000. Broadcasters air over 90 of the top 100 most watched programs. Perhaps more than anything, the quality of modern programming shows that the public is well served by the current system. Unfortunately, Many underestimate the substantial investment required to make it happen. The airwaves may be viewed as a public resource, but privately created broadcast systems and the programs transmitted over them are not. Local broadcasters maintain expensive transmission facilities and invest in new technology, including billions in the recent shift to high-definition broadcasting. They pay network affiliation fees and syndication fees. In an era of shrinking news budgets, the average local news operating budget is a welcome exception of over $4 million a year on average. In conclusion, there's no such thing as a free lunch. Creators and broadcasters need protection of their property rights that make this tremendous enterprise possible. In this context, it's clear that the public good, as Madison said about the intellectual property laws generally, fully coincides with the claims of individuals. Thank you.
Thank you, Professor Schultz. Mr. Love.
Thank you, Mr. Chairman, for the opportunity to testify. I've been asked to talk about the rights of broadcasting organizations, including proposals for a new UN treaty that would establish a set of neighboring or related rights for entities that distribute information they did not create and do not own. The UN agency responsible for development of intellectual property right policy is known as the World Intellectual Property Organization, or WIPO for short. Located in Geneva, WIPO has a standing committee on copyright and related rights known as the SCCR. Since 1998, the WIPO SCCR has been trying to obtain consensus on a new global treaty dealing with broadcast organizations. Several member states have called for a diplomatic conference on this treaty in 2015. There are major differences among countries regarding every important aspect of this treaty, as evident from the current working document SCCR/24/10 and the new proposals tabled during negotiations in December 2013. The WIPO Treaty would create a new layer of rights that coexist with copyright, benefiting the organizations that broadcast information. The broadcasters and several member states of WIPO, such as Japan and the member states of the European Union, are pressing for an agreement that would expand considerably the set of related rights that exist in a 1961 treaty, the Rome Convention, that the United States has not signed. The 1961 Rome Convention created a system of related rights for performers and producers of sound recordings to supplement protections that authors have under the Berne Convention. In 1961, a decision was made to give broadcasting organizations a layer of rights as a reward for their role as an intermediary between authors and audiences, essentially on a par with actors, singers, musicians, and other performers. Many consider the 1961 Rome Convention a mistake, and the broadcaster right as the weakest and least defensible type of intellectual property right, because it is provided by entities that play no role in the creation of the content itself. The United States did not sign the Rome Convention, but does provide some broadcasting entities with limited retransmission rights through the communications regulation system, including through 47 U.S.C. 325. At WIPO, several countries want to expand the Rome Convention beneficiaries to include non-free subscriber channels provided by cable and satellite, such as TNT, Hallmark Channel, ESPN, the Discovery Channel, or the subscriber-based radio channels provided by XM Sirius, and also give them rights in content they distribute but did not create. A growing number of countries want to extend the 1961 Rome system approach more broadly to the Internet and expand the economic rights to the more broadly defined group of broadcasting entities and provide for 50 years of exclusive rights on fixations of broadcast. At WIPO, USPTO has proposed a compromise that would establish a new right for broadcast, cable, and satellite services to, quote, authorize the simultaneous or near simultaneous retransmission of their broadcast or pre-broadcast signal over any medium, end quote. This includes the Internet, but in the U.S. proposal, no post-fixation rights. So far, no country has voiced support for the U.S. proposal, and much more aggressive alternatives from Japan and the European Union are being considered that would provide new economic rights to broadcast entities for distributing information they did not create or own. This is akin to giving Amazon or Barnes & Noble a layer of copyright in every book they sell, or making Google a part owner in every web page they locate on the internet. Free over-the-air broadcasters do face some unique challenges regarding the retransmission of their signals, and the U.S. PTO proposal at WIPO may be appropriate to address some of these channels. Here we have an open mind. But for pay services and webcasting, there is no need to create a new intellectual property right dealing with retransmissions. Copyright, theft of service laws, and contracts are sufficient to address piracy. For all broadcasting organizations, there is no economic justification for giving the distributor any rights in the underlying content. It does not make sense, and it creates a number of grave risks for those who create works and for the public to create rights for people that distribute information that lay on top of the underlying interest that you have in copyright. Thank you very much.
Thank you, Mr. Love. Ms. Griffin?
Thank you, Mr. Chairman. Good morning, ladies and gentlemen. As noted, my name is Patricia Griffin, and I am Vice President and General Counsel of the American National Standards Institute, ANSI, a not-for-profit organization that coordinates the U.S. standardization system. Most people don't know how much we depend upon standards to ensure our everyday life work. For example, standards help ensure that a light bulb fits in a socket, that you can use any ATM machine in the world, and that products on store shelves are safe. In the United States, our standardization system is led by the private sector, with hundreds of individual standards developing organizations, or SDOs, working in different technical areas and industry sectors. It is a consensus-based and market-driven process that is open to participation by all affected stakeholders. Importantly, the U.S. government is one such stakeholder, and federal, state, and local governments are active partners in the development of standards and codes when the activity is relevant to their needs. The government uses these standards in a variety of ways, including to establish internal procedures and develop regulations for public safety and welfare. Our national standardization system and its public-private partnership are reflected in the National Technology Transfer and Advancement Act of 1995 and the associated OMB Circular A119. The NTTAA directs agencies to consider the use of private sector developed standards in lieu of government unique standards. When adopting a voluntary consensus standard into a regulation, federal agencies are permitted to incorporate the standard by reference into the Federal Register without publication of the standard itself. For a standard to be incorporated by reference, or IBR'd, the agency must determine that the standard is reasonably available to the class of persons affected by the anticipated regulation. In this case, reasonably available has always meant that the standard is accessible to any potential user. It does not require that the standard be available without a fee. Now, recently concerns have been raised about whether the reasonably available requirement should be changed in light of expectations of free online access. For example, in early 2012, NARA, the National Archives and Records Administration, solicited comments on a petition arguing that IBR materials in the CFR should be for free. But just 3 months ago, after a comprehensive analysis, NARA concluded that reasonably available continues to mean just that, and it does not mean for free. They relied in large part on another comprehensive analysis of the issue conducted by ACUS, the Administrative Conference of the United States, in December of 2011. The question NARA was trying to answer was simple. Why shouldn't IBR standards be free? It seems like a valid point, but the blanket statement that all IBR standards should be free misses some very important considerations. First, Every standard is a work of authorship, and under U.S. and international law is copyright protected, giving the owner certain rights of control and remuneration that cannot be taken away without just compensation. Second, if SDOs can't charge for standards and codes, this disrupts the standards development ecosystem. The funding has to come from somewhere, and increasing participation fees to offset lost sales revenues would disenfranchise consumers and small businesses. Those with the money would have all the influence. Lastly, if SDOs can't afford to stay in business, safety standards would not be updated, and standards for new technologies would go unwritten. This would affect U.S. competitiveness and innovation. The government would have to step up, take over what is now a market-driven system, and somehow find the money, time, and expertise. So what is the answer? The public and private sectors should continue to make standards and codes available on a reasonable basis. For some, this may mean providing read-only but free access, and for others, it may mean at reasonable prices. Recognizing that there is not one solution to the access issue, NARA found that it is for the federal agencies to continue to work with SDOs to provide reasonable access to IBR standards. NARA's recent assessment reaffirms the decades-old guidance contained in OMB A119 that when copyrighted works are IBR'd, those works should not lose their copyright, and that government agencies must observe and protect the rights of the copyright holder. And that's just what's being done. Many SDOs make standards available for free or at a discount to consumers, policymakers, and small businesses. And some SDOs make certain standards and codes available online on a read-only basis. For its part, ANSI has launched an online IBR portal for the benefit of the user community, including consumers. In closing, the standardization community believes, as OMB, NARA, and ACUS believe, that the development of complex, highly specialized technical standards requires a massive investment of time, labor, expertise, and money. Standards development in this country is one of the earliest and most successful examples of the public-private partnership, which has benefited our nation tremendously on many fronts: competitiveness, public safety, successfully commercializing American innovations globally, and much more. Thank you so very much for the opportunity to testify for you today, and I'd be happy to answer any questions.
Thank you, Ms. Griffin. Mr. Malamud.
Thank you, Mr. Chairman, Mr. Ranking Member, and thank you for the opportunity to appear before you today. I'm the founder of public.resource.org, a nonprofit that puts government databases that everybody agrees are public on the Internet and then works closely with government to help them improve their own operations. I'm responsible for placing the SEC, EDGAR, and U.S. patent databases on the Internet for the first time. Public Resource has put all the historical opinions of the U.S. Court of Appeals on the Internet for the first time. We worked with Speaker Boehner and Chairman Issa to put a full archive of video from the House Oversight Committee and 14,000 hours of additional hearings online. I would like to highlight 3 key points. First, there's a fundamental principle of our democracy, the rule of law, that states that if we are to be an empire of laws and not of men, we must publish the edicts of government for all to know, because ignorance of the law is no excuse, and an informed citizenry must educate itself on its rights and obligations. That the law has no copyright because it is owned by the people is a principle that has been repeatedly reaffirmed by the courts. Despite that principle, my nonprofit has received stern takedown notices for publishing the official codes of Georgia, Idaho, and Mississippi. At the federal level, the Code of Federal Regulations deliberately and explicitly incorporates by reference public safety codes that become binding law. As Joe Baccia, the president of the American National Standards Institute, clearly states, a standard that has been incorporated by reference has the force of law and it should be available. My nonprofit has assembled a collection of 1,000 of those public safety laws, and we have made them available to the public for the first time on the Internet. For that service, 3 standards bodies are suing us for, and I quote, massive copyright infringement. They are suing us for publishing the law without a license. My second point is about money. Some standards bodies insist that before one can read or speak the law, one must first obtain their permission. They say everybody needs a license because they need the money. But the goal of their process is precisely that their safety codes become the law. They lobby aggressively for that outcome, and they boast loudly when their codes are adopted. When a safety code becomes law, the publisher gets the gold seal of approval of the American people. They exploit that position by selling all sorts of ancillary services, such as membership, training, and certification. The business has become incredibly lucrative, and these nonprofit standards bodies pay their CEOs million-dollar salaries. My third point is that the right to read the law and speak the law is necessary for innovation. Innovation that leads to better tools for those that use the law every day, including government workers, electricians and plumbers, students and apprentices, volunteer firefighters, journalists, and citizens. Mr. Chairman, I have here for the committee's inspection 20 public safety standards that are part of federal law, including the safety requirements for wooden and metal ladders, the safety requirements for protective footwear, the National Fuel and Gas Code. If you were to read these laws into your hearing record, would the Congress face strident objections for speaking the law without a license, like my nonprofit faces? That is why 115 distinguished law professors have joined me in calling on this committee to consider an Edicts of Government amendment to the Copyright Act to clarify once and for all that the law belongs to the people. Thank you very much.
Thank you, Mr. Malamud. I want to commend the witnesses. You've complied with the 5-minute rule, and I thank you for that, and we will try to respond accordingly. Mr. Schultz, what changes to U.S. law would you recommend to address broadcaster concerns about signal theft? A, and B, would these changes be to our copyright law or our communications law?
Thank you. That's an excellent question. The law as it currently stands serves well. As I testified, it serves both the public interest and serves the broadcasters well. There are current developments that could change that, notably the Irell case, regulatory proceedings, and a number of other court cases. But as things stand, the law works remarkably well. And indeed, even conceivably joining a new broadcast treaty would not require us to change the law. And thus, the current statutory scheme works well, and I'm not aware, although I don't speak on behalf of the broadcasters, I'm not aware, in fact, of the broadcasters seeking new rights. Thank you.
Thank you. Let me ask you another question, Mr. Schultz. In your work on copyright issues, what other issues of concern do you believe are of interest to copyright owners generally?
Thank you. I think indeed the subject of this hearing is an important one, including the making available rights. It's important that creators are able to secure the return on their investment and their labor, and that is currently a challenge, a quite obvious challenge in front of all of us. So I think in the long run that will need to be addressed.
Thank you, sir. Professor Lunney, do you believe that an explicit making available right would significantly broaden the scope of copyright protection beyond what it is today?
A making available right, if we use the language of the WIPO Treaty, would not change the law in the file sharing context by any measurable degree in the litigated cases. It would, however, open up potential issues in the public performance and public display areas, linking, retransmission, and issues of that sort for cloud computing and social networking sites. I think it would reopen some of those issues.
Now, does your lack of concern for the impact of file sharing reflect a view that Congress should reduce copyright protection in other areas?
I think one of the things that has sort of slipped in almost by accident to copyright law is that we've shifted over the last 20 years, or we've expanded copyright over the last years to get the individual consumer involved as copyright infringers. I think that's a bad development. For its first 200 years, copyright was directed solely at other commercial entities. I think it works best when it works in that fashion. When you start getting the individual consumers in the mix, either as infringers of one sort or another, you get the privacy concerns and other concerns. And I think that has created real problems for copyright law.
Mr. Love, do you believe that other nations are close to a conclusion at WIPO in drafting broadcast treaty?
Could you repeat that?
Yeah, do you believe that other nations are close to a conclusion at WIPO in drafting a broadcast treaty?
In 2007, we thought that the treaty was essentially stopped and there wasn't going to be further progress on it. After the Marrakesh Treaty was adopted by WIPO in June of 2013, it opened up a lot of space in the negotiations at WIPO. And it was, I think, quite surprising that in September of last year, country after country took the microphone at the General Assembly of WIPO to call for a diplomatic conference in 2015. I think the Secretariat of WIPO is looking for a hat trick. They'd like to have 3 treaties in hand in the copyright field, having concluded the Beijing Treaty in 2012 and the Marrakesh Treaty in 2013, and I think they're focused on that. We would prefer that there is no broadcast treaty. We're opposed to the proposal. But I wouldn't really, I think people are wrong if they don't think that this thing is moving forward. At this point, there's a large number of countries that are calling for a diplomatic conference. Once you go into a diplomatic conference, it's very difficult to predict what the outcome will be.
Thank you, sir. Let me try to beat that red light, Ms. Griffin. How does one respond to the statements of some that citizens deserve full access to the laws and rules by which they are required to live?
Yes, thank you for the question. I think that the answer to that depends upon an analysis of many dimensions. The first dimension is the recognition that standards and codes are original works of authorship and are entitled to copyright protection. And even at times when they are incorporated by reference into legislation, both the Second and the Ninth Circuit have held that those standards and codes do not necessarily lose their copyright protection by virtue of that. Another dimension of the issue is OMB A119 and the NTTAA. They encourage and demand that federal agencies incorporate standards into federal regulations when they are able to do so. A final dimension of the issue is the one that Mr. Malamud raises, and that is the one that says that the citizenship should have the right to see what the law is. The way that those 3 dimensions have been bridged over the course of the years is through a tool that's contained in the Freedom of Information Act, and that tool is called incorporation by reference. And that provides that federal agencies can incorporate into federal regulations extrinsic standards as long as those standards are reasonably available to the class of persons that are affected by it. And that tool has permitted the federal agencies to comply with their obligations under OMB A119 while at the same time respect the copyrights of the standards that are so incorporated. Recently, that's been challenged by Mr. Malamud and others, and they have gone to NARA and they have questioned whether the reasonably available standard ought not be changed to make the standards for free. And NARA has concluded, as has ACUS, that the current process continues to be the best one, the one that is best designed to ensure that high-quality standards are developed and incorporated by reference into federal regulation.
Thank you, Ms. Griffin. Thank you all. I see the red light has illuminated, so I now recognize the gentleman from Michigan for his questioning.
Thank you very much. Professor Nimmer, we appreciate you being with us today, and I'd like to discuss with you what you see as the key issues facing copyright industries and the public today when it comes to the current copyright system?
Thank you, Representative Conyers. It's obviously a very broad question, and I'll have to give a broad answer. I think the answer is that we are governed by a statute written essentially in 1965, passed in 1976, and now here in existence 50 years later with technologies that were not remotely contemplated then. And we see each of the rights of the copyright owner coming under strain. Today we've been talking about the distribution right and its making available component. You have already mentioned that the United States Supreme Court granted certiorari in the Irell case. That's a case about the performance right. And we see, because of the Internet, a convergence of all of those rights. So classically, back in 1965, there was a great difference between reproducing a book, publishing it, and then distributing it, and then a performance, which would be a play. Today, when the bits flow over the Internet, sometimes it's conceptualized as an act of reproduction, sometimes it's conceptualized as an act of distribution, and it's been argued in cases that it's equally a performance. So a very forward-thinking approach to copyright law would be to look at exploitation not within the prism of those 5 categories that are half a century old, but instead to try to formulate the ideal rules of the road going forward, which might be one unitary right, or it might be brought under the rubric of 2 rights or perhaps 3 rights. I'm not prepared as I sit here today to offer that answer, but I think it's exactly the right question to ask, and I'd be pleased to work with the committee on a going forward basis.
We appreciate that. Do you think the courts have struggled to apply making available right in the United States, even though Congress and government experts agree that the existing law should cover the right?
Yes, I do think the courts have struggled with that issue. I think one of the main reasons is that some of the individuals targeted have uploaded thousands of copyrighted works, and unfortunately, the result under our law is that somebody who's uploaded thousands of works might be liable for hundreds of millions, possibly even $1 billion worth of damage. That's why I think at the same time that Congress confronts the making available component of the distribution right, Congress should also rationalize the award of statutory damages. Right now, the scheme was set in 1999. The law happened to be passed right before the invention of a service called Napster. So our law is trying to keep pace with developments on the ground, and that's why I think a unified approach would be best, where we look at the making available right and statutory damages and a small claims court all in one unitary point of view.
And finally, I wanted to get an explanation of why you changed your mind on the making available right was not encompassed by the distribution right in previous editions.
Good, thank you. It's a challenge writing a treatise because any one sentence can be taken out of context and applied in a way that it was not intended. In particular, in 1995, there was a Second Circuit case in which somebody who owned Laurel and Hardy videos said his rights had been violated by CBS because they had broadcast his videos, and he was correct. But he said his distribution right had been violated by the performance of those videos, and the district court tended to agree with him. So the Second Circuit reversed, and I wrote up that case to say it's not enough that the works have been made available to the public in some sense by virtue of being broadcast. To violate the distribution right, there has to be actual distribution of their works, namely a physical copy passing hands. I wrote that in 1995, 3 years before Napster was formulated, so I did not have peer-to-peer services in mind, and unfortunately that sentence was taken out of context later.
Thank you so much. I'll yield back the balance of my time, Mr. Chairman. Thank you.
Thank you, Mr. Conyers. The chair recognizes the distinguished gentleman from Virginia for his statement. Mr. Goodman.
Thank you, Mr. Chairman. Mr. Nimmer, I'd like to follow up on the ranking member's question. Professor Lunney has raised concerns that adding a making available right would change longstanding jurisprudence. I take it you don't agree with that perception. Would you elaborate on your view, and does that view imply that Congress should never update the law for any reason?
Thank you, Representative Goodlatte. Yes, Mr. Chairman, I do disagree with that point of view. It all depends what type of law Congress were to pass. If Congress were to pass a standalone making available right, that would be a large change to copyright law. The way the cases have arisen to date concerning making available, it has been as an aspect of the distribution right. So cases construing the copyright owner's distribution right have come down on both sides of the making available issue. My testimony today, if we keep our narrow focus, is that Congress should clarify that the distribution right is violated when works are made available. In other words, when an individual uploads a copyrighted work to a share folder, it has thereby been made available to the world, and the act of copyright infringement is complete. It's not necessary to show a subsequent individual downloaded that work. And I believe that, therefore, a properly tailored amendment does not call into question existing cases that were rendered under the performance right or under the display right. Thank you.
Let me give everyone on the panel, and it's a great panel, by the way. I thank all of you for your testimony. A jump ball here. Since this hearing has covered 3 separate topics, are there any of you who would like to comment on any of the other 2 topics that you didn't get to testify in your opening statement? Mr. Love.
On the issue of copyright in the law, I think there is this distinction between whether the state laws and regulations in the United States can be copyrighted and what the federal. I think that the U.S. laws that works of federal employees, federal laws, federal regulations are not subject to copyright. I think it would be good to extend that rule to laws at the state level and everything from court opinions to regulations to statutes. And I also mentioned that the Berne Convention itself has a special provision that really gives governments extra flexibility in the area of testimonies, of legislation, of anything that basically smacks of law-type proceedings. And so I think that it is good that you focused on this issue, and I think that I certainly agree with what Carl was saying, which was that, you know, if you're expected to, my father was a judge, if you're expected to abide by the law, I think you have a right to know what the law is. And I think that it's good that this committee is looking at that issue.
Thank you. Professor Schultz?
Thanks. I'll briefly speak to standards. I think many of the principles I discussed apply equally to standards, that we need to ensure that the authors of standards can be compensated for their work. And I think Ms. Griffin did an excellent job of testifying, but we should all keep in mind that standards are incredibly diverse, and some standards have thousands of parts and thousands of subparts in those parts in the case of things like technical standards. So standards should not all be treated the same, and there should be due regard to the complexity and incredible expense and incredible public value that's created in standards. Thank you.
Thank you. This is another one for all of you. As the committee continues its work reviewing copyright law, are there topics in copyright law that you would recommend that the committee review? I will start with Professor Lunney.
I agree with David on this, that statutory damages is going to need to be revisited, particularly in the individual consumer context. It's a real problem to treat them as we are now, and hundreds of thousands of dollars in damages against a mom and a student. Just not appropriate.
Point well taken. Professor Schultz?
The Digital Millennium Copyright Act's notice and takedown provisions are broken. They are based on an outdated paradigm that seems almost naive now, that you could actually contain a file and stop it from spreading. It's no longer working for creators.
I noticed a piece just recently that said that Google had received its 100 millionth takedown notice.
Yes, and that goes both ways. Costs are symmetrical, right? That means hundreds of millions of notices have to be sent. Small creators, creative upstarts, individuals, thousands, tens of thousands of people who make a good middle-class living can't afford to spend all their time trying to chase people around the internet. This system is not working for them. It needs to be revisited. Thank you.
Mr. Love?
I think that revisiting the issue of formalities is quite important. I think that the decision to introduce formalities in the United States has created a wasteland of cultural works which are essentially inaccessible to people. I don't think anybody can go back very far before you realize it's impossible to identify who the owners of a lot of works are, in some cases who the authors are, photographs, old pamphlets, literature. There's a variety of proposals that have been made to deal with orphan works, but one of which is to consider the flexibility you have on formalities. Certainly for the post-TRIPS requirements of 20 years on photographs and 50 years on copyright, you can introduce formalities for that extended period. And there's a proposal in the TPP negotiation to do that very thing, actually, that the U.S. is actually opposing, and I think the U.S. is on the wrong side of that issue. Another thing is that on sound recordings, which are not protected by the Berne Convention, there's no obligation to have formalities. And so for not all things that are considered copyright in the United States are actually required under our international obligations, the Berne Convention have formalities. So I think a deep and technical look on where you can introduce formalities. Some people, like in the recording industry, have expressed some openness to the idea that it would be a good idea to sort of give more protection to people. I'm sorry, I want to wind this up. And the final thing is that the Treaty for the Blind provides an opportunity for the United States to share its collections of works done under copyright exceptions with blind people in other countries. And I think that needs to be fixed.
Mr. Chairman, my time's expired, but I know Mr. Nimmer wanted to jump in on that as well, if I may.
Objection.
Thank you, Mr. Chairman. The written statement that I submitted put two other matters into the hopper. One is the United States Supreme Court last year ruled that gray market goods can be freely purchased abroad and imported into this country. Justice Breyer's opinion said, we think that this is what Congress intended. If Congress did not intend it, then Congress can come back and tell us. So that is something that is very live now. And there's a parallel issue in the domestic front, which is cloud computing. It introduces wholly new rules of the road. It essentially eliminates the safeguard of the first sale doctrine, and Congress needs to look at what rules it wishes to have for the road of this uncharted territory of the cloud.
Thank you, Mr. Chairman.
Gentleman's time has expired. Ms. Chu from California.
Thank you, Mr. Chair. As the co-chair of the Creative Rights Caucus, along with Chairman Coble, I believe that a making available right is ingrained in our current statute as an essential part of our copyright framework. Congress has repeatedly concluded that no change to the U.S. copyright law was necessary because existing law already includes a making available right. Our federal appellate courts have also arrived at the same conclusion, and this is also the case in various international agreements such as WIPO and the WIPO Copyright Treaty. I believe that the making available right is an inherent and exclusive right that gives the creators the freedom to express themselves and, more importantly, to decide how and when they choose to distribute and publicly perform their own works. So Professors Nimmer and Lunney, what, if any, impact would carving out a separate making available right to the Copyright Act, what effect would that have on online theft? Would explicitly creating a making available right help lessen the burden for individual creators or make the process easier for them to prove their works have been infringed upon?
Thank you, Representative Chu. I believe it would streamline the cases. Instead of having a large federal case about every activity of peer-to-peer sharing, there could be an expeditious proceeding, particularly if Congress also adopted my suggestion of having small claims court proceedings. And I think it would be a salutary change to streamline those procedures and get quick and fair and expeditious justice in them.
Well, as you might guess, Representative Chu, I disagree with Professor Nimmer. It used to be under Napster that you would go on and find one user who had the file and you would download it from that particular user. That sort of file sharing protocol has largely faded away. Most file sharing today is with BitTorrent. The file is divided up into separate segments and is sent out in a swarm of people who are all simultaneously uploading and downloading the work. So the issue of whether you have to prove a download as part of your prima facie case is essentially irrelevant under the BitTorrent protocol, whether we have the making available right or the existing distribution right. As a practical matter, almost all of these instances where file sharing is found, what happens is the investigator identifies the person, the IP address, they go to court, they get the subpoena to the ISP to get the consumer's information, they send the threat letter, and that's as far as it goes. It's either settled or the consumer can present some sort of evidence that they were not the person who did the downloading, and that's it. Only a relative handful, maybe 20, 30, 40, a few hundred, actually ever go any further than that. And if it actually goes to trial, they get a copy of your hard drive, and at that point it's relatively trivial to prove the file sharing activity you've engaged in. So I don't see how this would really facilitate or help sort of small creators.
And Professor Schultz, you look like you have an opinion on this.
Oh, no, thank you.
Then, okay, Professor Schultz, then let me turn to a different issue, which is I'd like to ask specifically about the Irell case. Of course, we know that the Supreme Court agreed to hear the Irell case to determine whether online streaming of live broadcasts constitutes an infringement of a copyright holder's exclusive right of public performance. Given the economic importance of intellectual property in our country and the constant evolution of modern technology in which more people are viewing content over the internet, is this an appropriate question for the courts to determine, or should Congress legislate and settle this area of law? And how would a decision favorable to Irell change the landscape of how broadcast content would be delivered to consumers in the future?
Thank you. That's an excellent question. I think I'll begin with the second part of it. How would it change the landscape of broadcast? Irell's not the only court case that the broadcast and television creators, broadcast industry and television creators face. We have one court saying that essentially intercepting signals and aggregating them and sending them to their customers in Irell does not require payment of retransmission fees. We have another court saying that stripping commercials out of broadcasts is perfectly okay. We have another court in Cablevision essentially saying that a virtual on-demand service is permissible. And when all this is said and done, you have to ask where the revenue is going to come from. How these companies will get compensated for their work. So I think an Irell decision that comes out in favor of Irell would undermine the very premise on which the system is based, that local broadcasters can be compensated for the tremendous investment they have in broadcasting, and content creators can be compensated for their work. So I think that this is an appropriate topic for the courts, but if the courts interpret the Copyright Act in a way that undermines these fundamental policies, this Congress will have to act. Thank you.
Thank you. I yield back.
Thank you, Congresswoman. The chair now recognizes the gentleman from North Carolina, Congressman Holding.
Thank you, Mr. Chairman. Professor Nimmer, maybe this is best directed towards you, but could you take a minute or two and explain further how U.S. copyright law compares to that of other nations, particular distinguishing features?
Okay. The theory of Anglo-American copyright law is basically instrumental, that it's there for a purpose, to promote the progress of science. In the continent, in Europe, the underlying theory is much more based on natural rights, that there's an intrinsic connection between the author and the author's creation. And so therefore there is a natural right to compensation just by virtue of having created, regardless of the social policy that will come out of that activity of copying. So that's the broadest answer to your question. The philosophical underpinnings that I've just outlined obviously play through with practical implications. We see in continental jurisprudence a very strict recognition of moral rights, which is something that is alien to the U.S. way of copyright and was only put in grudgingly and only with respect to works of visual art in 1990, and it plays out in other ways as well. That's a very brief answer to an extremely interesting and broad-ranging question.
Well, maybe we could dive down on some specifics in the context of, we're negotiating some trade agreements, TTIP in particular I'm thinking of. What type of copyright issues might be brought up in that context, and do you foresee any divergences which could cause particular arguments?
Let me ask Representative Holding, are you talking about the free trade agreements that are being negotiated?
Right, correct.
Okay. Insofar as I'm aware, the U.S. government has had great success in reaching agreement with other countries with respect to those free trade agreements. There are 20 countries now with whom the U.S. has bilateral relations. Those treaties do, I think every single one of them, possibly with one or two exceptions that I'm not aware of, include a making available right. And so notwithstanding the philosophical differences between different countries with differing roots of copyright, there has not been disagreement insofar as I'm aware with those free trade agreements.
And I'd like to open it up to the panel if anyone else would like to chime in with particular issues having to do with our copyright laws versus other nations and problems there. Yes, sir, Mr. Love.
The U.S. has high norms as far as damages are concerned. A lot of foreign countries have lower norms as far as damages, but the U.S. has broader fair use rights. And so the combination is such that, say, our technology companies, which are really dominant in a lot of the internet areas, have been able to operate. What the U.S. is doing in the free trade agreements is sort of cherry-picking the parts of the U.S. law that in some cases, that the publishers like. So they sort of pick really aggressive standards as far as damages, to the extent they're even requiring countries consider the full retail value as the basis for damages, for example, which isn't even found in U.S. law and is contrary to U.S. law. On the one hand, and then kind of a half-hearted way of looking at the fair use thing and the thing. So what you've got is sort of a shift of increased liability for U.S. technology companies operating overseas. U.S. has, it has strong damages, but we have more exceptions in our domestic law than most foreign countries do, which is kind of this paradox. I think the problem in trade policy also is that the negotiations are completely secret. We helped leak the September version of the TPP negotiation, a negotiation involving something like 40% of the world's GDP in that negotiation. We don't know what the current version is, and neither do you. Now, I don't see how you could possibly expect a trade agreement with Japan and Mexico, basically NAFTA squared, triple squared, with that much GDP on the table, and not even know what's going on and not even have that thing transparent. So I think that the Congress has fallen down by allowing copyright policy to be made in secret through these trade agreements.
Thank you. Mr. Chairman, I yield back.
I thank the gentleman from North Carolina, Mr. Dutch, the gentleman from Florida.
Thanks, Mr. Chairman. Professor Lunney, I wanted to pursue in a little more detail some of the assertions that you make in your written testimony. All of this sort of to support your assertion that there's no need for a making available right. You say the unauthorized copying, distribution, and streaming of copyrighted works across the internet are not the problem that copyright owners would have us believe. You talk about the purpose of copyright is not to maximize revenue, but to make the works more widely available. You said here today that the measures of music output is what we should look at, not the money made. The goal is to promote more and better works, and file sharing encourages that. And you went on to say, even while formally illegal, file sharing has provided much broader access to existing works than the pre-existing market mechanisms had accomplished. And there are a few things I'm trying to wrap my arms around. First, you had said earlier that the copyright laws in this area had always focused on, never on individuals, but always on corporations. And I wonder if you draw the distinction at the individual who downloads a song or a movie illegally, and what happens when that individual creates an opportunity to share hundreds and thousands and tens of thousands and millions of songs and movies and other copyrighted work that can then be shared with others. Clearly, in that instance, file sharing goes beyond what you're prepared to accept.
Thank you for the question. It is a hard area to get our hands around, and it is counterintuitive to suggest at some point that less revenue could lead to more works. It would be a surprising result. I was surprised by the result when I did the empirical work myself. And of course, from my perspective, I'm sort of an ivory tower academic. I don't expect my work to have any real-world significance. I'm not sure I want it to have real-world significance. I want to sit and explore issues and try and figure things out. And so you get a result like this, and you publish it, and all of a sudden you're the center of a bit of controversy. Obviously, copyright is not a never-ending spigot. You can't simply add more and more and more and more and expect to get more works out the other side. There's got to be diminishing returns at some level.
You know, Professor Lunney, I'm not asking you to restate your testimony. I understand it. I'm just asking, when you say that file sharing, that the sharing of copyrighted material is okay, is it okay just for an individual, or is it okay for an individual to share tens of thousands of songs or films?
Well, if there's file sharing, there's the potential, at least, for sharing tens of thousands of songs to tens of thousands of people. And we've assumed that that has the same effect as if a competing commercial publisher came along and offered competing copies in the marketplace.
Well, except
that's an assumption.
How is it different? How is it? Here's what I really don't understand with the argument that file sharing, illegal file sharing, is somehow okay. If the goal is to spread the amount of music and creative works and film and all of this great intellectual property, and to spread it as far and as wide as possible, why is it different in the computer, in the setting of technology, to share files that way than it would be for the big box retailer to have someone come in through the back door, scoop up all the CDs and DVDs, and take them out on the street corners after they've copied them tens and hundreds of thousands of times, or gone into business on their own? Why is it different with a physical product than it is online?
Well, it's different when consumers are doing it than when a commercial entity is doing it, I was arguing.
Right, and I'm suggesting to you that individual who breaks into the big box retailer and scoops up maybe only one or two, takes a couple of CDs and DVDs and makes copies of those, him or herself, and then goes ahead and shares those, spreads this information far and wide, gets all this intellectual property out there. Why is it different? Why should it be acceptable for that to happen online but not on the streets?
So is this individual who's breaking into the big box, are they offering those copies for free, or are they
Is that the
charging
distinction? Is that
I think it is an important distinction, whether it's for-profit or not for-profit.
Right, and so if we had just someone whose goal was really just to spread the great American intellectual property that we're all so proud of, by making copies and distributing it out of his or her own goodwill, thousands of copies, tens of thousands of copies, millions of copies, that's perfectly acceptable.
I think we do have such individuals. I think they're called libraries. And they've coexisted with the commercial market for hundreds of years without undermining it. I think that's...
Right. They have libraries that operate and have operated, as you point out, for hundreds of years, not the setting of people who are going to make millions of copies to then freely distribute to be used without any regulation. I don't see the difference. And your example, and this is what's also confusing to me, when you talk about the fact that, as you explain, you say, you know, the question isn't whether file sharing has caused a decline in record sales, but the decline in record sales affected the creation of new music. And you talk about other ways that, that creators can be compensated, separate and apart. Then you go through all of them and conclude yourself. You reach your own conclusion that all of those other areas are not enough to make up for the amounts that are lost as a result of the theft of all of this intellectual property that you think do-gooders are certainly capable of doing to spread this intellectual property, which makes the performers better off and makes the songwriters better off and makes the actors and actresses and everyone involved in the production of any film or TV show. You seem to refute your own argument, and ultimately your conclusion is, yes, you do acknowledge in a footnote that, yes, there is less money going to the industry, but that it's not fair to point out that that may mean there may be fewer creators willing to engage in their work. All that means is that if you had tougher enforcement, that the dollars that flow to those industries are dollars that would have otherwise been in other industries, that your rationalization doesn't seem to make sense. Ultimately, the conclusion that you reach that somehow it's in the best interest of creators in our country for their creative works to be spread far and wide without compensation. And as you've now acknowledged, not just a couple of kids trading songs that hopefully they purchased, but in fact the spread of tens of thousands or millions, that ultimately the goal is just to spread that, and that the diminishment in the amount of compensation to those creators will have no impact, you say, on their ability to continue to do their job. It just doesn't, it's inconsistent with what all of those that I talk to who rely on copyright to protect their intellectual property, it's inconsistent with what they tell us they need in order for us to continue to uphold this great American intellectual property that we value so much. And I yield back, Mr. Chairman. Thank you.
Thank you, gentleman. The gentleman from Pennsylvania, Mr. Moreno.
Thank you, Chairman. Lady and gentlemen, I wish I had 3 or 4 hours to sit and discuss these matters with you. It's been very enlightening. Ms. Griffin, you made a statement concerning standards and how they apply to life in general. Do you think that we could be served by the industry itself setting standards, or do you believe that we need to legislate more?
I think that clearly the way the system works now is a public-private partnership with standards developing organizations who have technical expertise working with the federal regulators who are in their space. And together and through that partnership, they develop regulations that best meet the requirements of the regulated, whatever that may be. And in this country, that's a very diverse group of people, and there are very many groups that do that. But what the standards developers organizations bring to that is providing the administrative support that permits the group that sits at that table to be open and balanced and transparent and not dominated by any one group. And they provide the administrative support for having consumers sit at the table and provide input that would not otherwise be provided if it was just a government-driven event. So I think that balance is what makes it fulsome and it makes it the system that it is.
Thank you. Professor Schultz, you talked about notice of takedown. Let's have a little example here. I have a search engine. I create a search engine, name it after my son, Victor's Search Engine. And you are a musician and a writer. You choose whether you want to be the singer, the writer, or the musician. But at this point, you have a record out, you have a CD out, you have music out, and I do not buy it from you. You're paid no compensation from me, but when people put your name in my search engine, your music comes up, and you send me a notice, and I do nothing about it when your music comes up because I'm the guy who is illegally selling music to people, and you're not getting paid for it, and you keep sending me notice and notice and notice. What do you think should be done about that?
Thank you for the question. I think, indeed, there are two difficulties you identify here. One is that the current notice and takedown system is based on identifying a particular file rather than a work. And as I said, it's based on an old paradigm that, what we had to do back in 1998 was stop a file that had escaped onto the internet, quarantine it, and pull it back. It's naive now. And now, every time somebody's work is infringed, they have to send a separate notice for every file, no matter how often.
Do you think I should be held responsible, even though you're not sure how many people are downloading that music? Because every time someone gets on my search engine and pops your name in there, your music comes up, and I'm selling it to somebody for 10 cents a pop.
Yes, absolutely. If you're the site hosting and profiting from somebody else's work, whether it's through advertising or
do you think I should be held criminally liable?
Criminally liable. That's a more challenging question.
I'm stealing from you.
So,
I was a prosecutor for 18 years, so I'm stealing something from you and selling it and making a profit off it. Do you think I should be charged criminally?
Of course, we're going beyond the scope of these hearings today, but yes, I think criminal law can be a useful tool, but it has to be very carefully applied to instances where the user's at a great disadvantage. Thank you.
Professor Lunney, let's have another example. Instead of a brilliant attorney, you're a poet, struggling poet. You live in a one-room apartment above a factory, and you don't even have heat in the winter. And you write, I'm looking through, I'm a songwriter, and I'm looking through your book of poetry, and I find this magnificent poem that you wrote. And I take that and I put it to music, and I make $10 million on it. Do you have a problem with that?
The issue of derivative works is a difficult one, and I personally would not have a problem with that.
You personally, for struggling,
no,
hardly eating, you write this book of poetry and you don't have a problem with it?
I feel that in a lot of the derivative work context, it's the inventive effort and creativity of the second comer.
Okay, let's go back. Now your father is a great poet, struggling though, and trying to keep a family. And again, I use his poetry, and I make $10 million on it, and he can't feed his children. Should anything be done about that? Do you have a problem with that?
Well, I'm not sure exactly what you're doing with this poetry, but if you're just...
I'm selling it and making a lot of money on it because I'm putting it to music.
Are you selling it in music, right?
Yeah.
So it's a derivative work, not the market he originally exploited. He was just a poet.
He was just a poet.
And so
he wrote a book, and he really wanted to sell it, and it's not making good, but I took a poem out of that book, and now I made $10 million, and he can't feed his kids.
Right. My perspective on a lot of the derivative works is that we shouldn't require necessarily license in all those contexts, but it's really the derivative author who adds the real value to that.
We tend to disagree on that. I think I'd be a little angry if my father said, we're not eating here today, folks, but, I think this guy should be able to take my work. I yield back. Thank you.
Thank the gentleman from Pennsylvania. The gentlelady from California, Ms. Bass. Ms. Delbini, I stand corrected.
Thank you, Mr. Chair. Mr. Nimmer and Professor Lunney, if we were to clarify the making available right in the law, do you think that would raise any First Amendment or free speech issues? And if so, what do you think we might be able to do to avoid those challenges?
I believe that a simple clarification that the copyright owner's distribution right includes making the work available does not implicate any First Amendment special interests that do not arise automatically in copyright law anyway. So I believe we do not need to pay special attention to that. It could be that if Congress wished to have a special surgical intervention in the peer-to-peer domain, for instance, because of the spate of pornography lawsuits, if Congress wished to limit the protection for pornography, that might be a way to redress the problem that would then raise the question of what level of First Amendment scrutiny would apply, and is there sufficient governmental interest to satisfy that. But straight making available aspect of the distribution right, I believe, does not raise any special First Amendment concerns.
I actually agree with David exactly on this issue. If you passed a very narrow amendment, for perhaps creating a presumption that a work made available in a sharing folder could be presumed to have been downloaded, so that it would be infringement under either interpretation of the existing distribution right, I don't believe that would raise any First Amendment problems. If you pass a general making available right, raising questions about whether a link might be an infringement of the public display right, or whether cloud computing or social networking, you're going to get into some First Amendment issues there. And I also agree that if you try and go after copyright trolls by differentiating the copyright protection for porn versus other types of audio-visual works, that may raise First Amendment issues.
So if we feel that the making available right is implied in the law today, why do you think the courts are having so much difficulty with this right now, Mr. Nimmer?
I believe the elephant in the room is the amount of statutory damages, so that when a young single mother is clearly culpable of copyright infringement, and yet she could be held by the jury liable for $100 million in statutory damages, the courts are reluctant to apply the law as written. So that's why I'm urging Congress to have a global solution at the same time that it reaffirms the making available aspect of the distribution right, that it would cabin statutory damages to a reasonable extent.
And do you agree with Professor Lunney's statement earlier that making the or having an explicit reference to a making available right would cause economic harm?
I'm not positive which aspect of Professor Lunney's statement you're looking at, but I come at the economics very differently than he does. So suffice it to say that it's a very interesting study, but what it does not illuminate is how much music would there have been created in the last 10 years of lowering studio costs had there not been peer-to-peer illegal file sharing.
Professor Lunney, do you think there's any way to define a making available right more specifically that wouldn't cause old cases to be reopened and the uncertainty that you talked about earlier?
Yeah, there certainly would be. If you just want to affect it in the distribution, the peer-to-peer file sharing context, you could create a presumption that a work that's made available in a share folder has been downloaded. You can even make it a rebuttable presumption if the defendant wants to come forward with evidence, but it'll never get that far. It never gets that far in any of the existing cases. In the one case where it was raised, the Jamie Thomas Resett case, she was found guilty of filing copyright infringement the first time with a making available instruction on the distribution right. It was retried after the district judge said, no, that's not right. She was still found guilty.
Thank you. I yield back my time, Mr. Chair.
I thank the gentlelady. The gentleman from California, Mr. Issa.
Thank you, Mr. Chairman. And Ms. Griffin, I asked a lot of documents be placed in the record earlier, and most of them are related to the gentleman next to you, Mr. Malamud. It's an amazing thing to me that I came from a standard-setting organization, Electronics Industries Association and CEA, and you couldn't have a high-definition television if we hadn't figured out what the standards were going to be. We wouldn't be arguing over capturing of digital broadcast if we didn't have digital broadcast. Standards are extremely important. But standards and laws are different. And I'd like to concentrate with someone on this end of the table. Mr. Malamud, I'm going to read just the shortest part of the Constitution for a moment, where it says to establish post offices and post roads. Post offices are next door. And it says to promote progress, and I'll skip over of science and useful arts for a moment, and limited to, and of limited times. And I'm just going to read how it relates to copyright. To promote the progress for limited times to authors. Okay, that's it. That's the Constitution. It's only a paragraph. To promote progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. But that short one, to promote to authors. Who authors a law? And that's my point, and it's the point of all the documents I put in. If the state of Idaho, the state of Georgia, the state of Mississippi If they produce a law, every single person who voted for it is an author. It doesn't belong to some entity by definition. Isn't every law, in fact, and I got to tell you, Obamacare has people who do not want to be authors, and others a few left who do. But on the day that it passed, we were all authors. So my question, and I'm going to concentrate on this end and then open up to the rest, is, in its rawest form, isn't in fact every single person who participates in the creation of a law or the inclusion by association of a standard, in fact, an author? And therefore, if I'm willing to have it released to everyone as an owner of that copyright, an undivided owner, don't you ultimately have no possibility of protection? In other words, the state of Idaho is inherently wrong if they consider any part of a law required or mandated to be, in fact, eligible for copyright. And my point here, and Carl, I'm going to go to you first. I've been in Congress for 13 years and about 8 days. The one thing I know is I don't need a copyright to promote politicians making laws. So by definition, the promote being the basis for copyright, don't we inherently have a decision to make about whether or not laws or anything else which is included in a law by mandate has any right to a copyright at all? A fundamental, forget about what we do with this copyrighted material, is it really eligible for copyright?
Congressman Issa, thank you for that question. I think that is the crux of the matter. The VEC court, when it looked at whether the Building Code of Texas had the law, said that there is no incentive needed for the
politicians
employees.
Will make laws whether you
absolutely.
You just have to pay them per diem and they'll show up.
And the standards bodies, I've never seen a standards body object to one of their documents becoming incorporated by law. That is often the case. I think that's especially crucial on public safety laws. Now, we may incorporate by reference too many things, and perhaps the guidance of this committee could be used on that topic. But for those that are crucial, for example, the laws on testing the toxicity of water is something that every citizen in West Virginia today wants to know what those laws are and were they carried out properly. And I think that is the key point. You can't have it both ways. If the document is in fact the law, it has to be available. And I respect the rights of the standards bodies to develop a wide range of standards, but once one of those has become the law, then it needs to be available. Now, again, a standards body can say, please do not incorporate this into law. We would prefer that this document not become the law. And that is perfectly acceptable. There are multiple standards bodies. There are several fire codes, several building codes, several plumbing codes, and you will find immediately a group standing up and saying, please designate mine to be the law.
And Ms. Griffin, I'm going to ask you the follow-up that goes along this line quickly. What Mr. Malamud said is what I'm trying to make a point on. If it is a voluntary standard, in fact, it's available for copyright. I understand that. But if it is incorporated in law, at that point, shouldn't you object to it being incorporated or recognize that you're waiving any copyright objections from the public having free and fair access to essentially a law that they must comply with?
Thank you, Congressman. I think the answer is incorporated into OMB, the policy of OMB A119 and the NTTAA. And those policies and those laws dictate that government agencies, federal agencies, incorporate voluntary consensus standards in lieu of government unique standards whenever they are able to do so.
Okay, but OMB is nowhere enshrined in the Constitution, and it does not have explicit legislative authority. This is the committee that must decide what can or cannot be covered under the promote and an exclusive element of copyright. And the rest of the panel is extremely important, and we work on it all the time. But in a digital age, narrowly, Mr. Chairman, the law and people's access to laws which they must comply with, inherently, this committee has to decide whether that should be stripped of any and all copyright to the extent that we have authority, which has nothing to do with what OMB thinks, because quite frankly, they think they can make laws without Congress getting up in the morning ever again. So constitutionally, on what basis would you say that has any grounding, not what OMB thinks?
Well, let me tell you what the Second Circuit and the Ninth Circuit...
Ms. Griffin, if you could be as briefly as possible, time has expired.
Yes, but let me tell you what the Second Circuit and the Ninth Circuit said on that very point. In the PMI case, the Ninth Circuit said that the due process requirement of free access to the law may be relevant, but does not justify termination of, and in this case, it was the American Medical Association's copyright. There's no evidence that anyone wishing to use the standard at issue in that case had any difficulty in obtaining it. And that was the PMI case in the Ninth Circuit. The Second Circuit, in a similar case in CCH Info, said we are not prepared to hold that a state's reference to a copyrighted work as a legal standard for valuation results in loss of copyright. While there are indeed policy considerations that support CCC's argument, they are opposed by countervailing considerations. For example, a rule that the adoption of such a reference by a state legislator or administrative body deprived the copyright owner of its property would raise very substantial problems under the taking clause of the Constitution. Although there is, and I'm jumping to the last sentence of that paragraph, although there is scant authority for CCC's argument, Professor Nimmer's treatise opposes such a suggestion as antithetical to the interests sought to be advanced by the Copyright Act. So at the end of the day, it is a balance. It's a balance between the rights of copyright holders and the value that those copyrights bring to federal regulations. As I said earlier.
Thank you. And Mr. Chairman, I appreciate your indulgence, and I just want to go on the record that in the copyright reform that we are considering as a committee, in order to have my vote on final passage, we will have to rectify the ambiguity in the law so that every American has free access to every law that he or she must live under.
I thank the gentleman from California. Thank the witnesses. There will be ample time after the hearing for exchanges between the witnesses and members of the subcommittee. So nobody's being shoved off abruptly. Shoved off, perhaps, but not abruptly. I thank the gentleman from California. Mr. Jeffries, gentleman from New York.
Thank the distinguished chair and thank the witnesses for their testimony. I want to start with Professor Lunney and try and get some clarity from, or as it relates to some of your written testimony on pages 6 and 7. Bottom of page 6, you state that, as has been previously discussed, the purpose of copyright is not to maximize the revenue of the music industry or copyright owners more generally. Is that correct?
Yes, sir, I do take those statements from Supreme Court decisions setting that forth and repeat them.
Now, is it fair to say that copyright owners or content creators are entitled to reasonable compensation?
I think we'd have to sit down and define what reasonable is, and that would be a more difficult task than you might imagine.
So you don't take the, is it your view that copyright owners or content creators are entitled to any compensation whatsoever?
No, it's not my view of that sort at all, and I would be happy that they would be very well paid. My only perspective is that in terms of the constitutional purpose, our focus should be on the production of output. Now, obviously, a well-compensated artist and musician class is probably important for long-run copyright output of creative works.
Okay, let's focus on the Constitution. I appreciate that observation you just made. So the relevant provision, obviously, is Article 1, Section 8, Clause 8, which reads to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, the progress of science part of that provision obviously gives Congress, I believe, the ability to create a robust patent system. Is that correct?
It's actually the promote the progress of the useful arts is for patent. Science is for copyright.
So you've defined the, right, and what would be the basis of that conclusion? Does that stem from your evaluation of writings from the Founding Fathers, or?
Supreme Court has said that on a number of occasions. The clause has a parallel structure to promote the progress of science and the useful arts for authors and inventors, their writings and discoveries. Each of those three pairs of words, the first word is for the copyright, the second word or phrase is for patent.
And so the Supreme Court has defined this standard, I believe, to encompass two legitimate ends, correct? The first would be encouraging the creation of new works. Is that right?
That's correct.
And then the second would be to encourage the dissemination of existing works, correct?
That is what the court said.
So now, as it relates to encouraging the creation of new works, is it fair to say that providing artists, content creators, with the opportunity to benefit from the fruits of their labor in some meaningful way serves the purpose of encouraging the creation of work?
As a general proposition, I have no disagreement with that statement.
Okay. And what would you disagree with as it relates to that statement?
Well, it's always a question of how many rights and how broad the rights need to be. Do we need to address every specific instance? In the Academy, we talk about leakage in the copyright system. That is, instances where individuals or companies copy and yet they're not sued or it would not constitute copyright infringement. And this leakage is a fairly important part of the system. So trying to determine whether any given instance of copying, some are reasonably straightforward. I would agree, I think we would all agree, that a commercial competitor who takes a copy and sells it for less in the same marketplace is a copyright infringer. I think we'd all equally agree that someone who takes Shakespeare's Romeo and Juliet and creates West Side Story would probably not be a copyright infringer.
And am I correct that it's your position as it relates to determining the measure of what happens when meaningful or reasonable compensation is not provided is that we should simply allow for the illegal dissemination or reproduction or sharing of works and then evaluate whether content production has decreased? Is that your position?
No, I'm not advocating sort of randomly changing the law to see what happens. As a social scientist, I might be interested in that experiment. But file sharing gave us an opportunity to see what might happen. It was formally illegal, but it nevertheless happened, and revenue to the music industry, even considering all the revenue sources they have, definitely went down. So what happened to output? And what does that tell us about whether we had not enough copyright, too much copyright, or just the right amount? And if revenue goes down sharply and your copyright protection effectively falls, and yet you seem to get as much or more creative output, for me that suggests that we may have had too much copyright to begin with.
Should we be concerned about the impact on the economy in that scenario?
Well, it depends on what you mean by the impact of the economy. For me as an economist, the fact that some money doesn't flow to the music industry, it's going to remain in the consumer's pockets, it's going to be spent elsewhere in the economy. Jobs lost in the copyright sectors will presumably be picked up if consumers spend that money on education or employment or health care in those sectors of the economy.
Lastly, Professor Nimmer, you referenced earlier in your testimony that facts change on the ground. And I believe you may have mentioned it in the context of misinterpretation of a line in a treatise that you had prepared, which preceded the development of Napster. We've also seen the advent of streaming. Cloud computing is another example. Technology changes over time. That's a wonderful thing. I think many of us would agree. The issue is, how do we accommodate technological changes as they move forward, but also create the certainty in the law and the copyright protection for the creative community? Do you have any words for us on the committee in terms of how to strike that appropriate balance, if that is the balance we should be seeking?
I certainly do agree that it is the right balance. At the end of my written statement, I reproduce one page from 50 years ago. It's from the Register of Copyrights, written in 1965. And it said, we don't know what the law will be 10 or 20 or 50 years from now, and they're writing 49 years ago. But they said it is becoming increasingly apparent that transmission of works by linked computers may be among the most important means. And the final statement was, we believe the day is past when any particular use of works should be exempted for the sole reason that it is not for profit. So those are very wise words to guide us as we go forward. This was written at the culmination of 10 years of study, and I think it beautifully encapsulates much of the philosophy that needs to go in. So that would be my watchword for Congress on a going forward basis.
Thank you. My time has expired. I yield back.
Thank the gentleman from New York. Professor Lunney, I owe you a belated apology. I previously mispronounced your surname. You are not Lunney. I stand corrected.
I always tell my students it rhymes with funny and I'm not crazy.
And and hold me harmless for my mistake. The gentleman from Georgia, Mr. Collins, recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate that. And then, Mr. Lunney, I think inadvertently you may have summed up this entire discussion. From my perspective, and many in this room know this, I believe that copyright protections and other protections not only at the proper balance strike innovation and help innovation, but also protect innovation and grow apart. And you made a comment in the midst of an exchange when you said, and with my gentleman from Pennsylvania, you said it's just a poet. And that struck me, and it may come strangely to others, just a poet. Poets have changed the world. And their words mean something, their copyright protections have mean something. I think for me, I think that sums up this entire hearing, that there needs to be a proper balance struck. But when you just say it's just a poet, it's just a writer, was Hemingway just a writer? Was Dickens just a writer? Was Clancy, even new, just a writer? That's the heart of what we're talking about here today. And it was not meant in any way, except you just sort of summed it up in an offhanded way, but I think that's really where we're at today. But I'm not with you. I'm down here with Mr. Malamud. I want to continue off of the discussion that my friend from California discussed. That's the definition of law, and we do have an interesting comment here because I am from Georgia, and you have let's just say a difference. And I appreciate all of what you do. I think what you do is really a service, a public service. I have a problem with where we're at right now, a little bit with what we're defining. And in your letter to the Senator McCoon, Speaker Ralston, and Pro Tem Schaefer in my state of Georgia, you said the official code of Georgia annotated every component of it is the official law. I want to explore that a little bit. And I just have some short questions so we can get to a little bit more. What is an annotation?
An annotation can be anything from some freelance editorial comment by some commercial provider to the comments by the Legislative Council or the state itself as to the import of the code.
Thank you. Is an annotation a statute?
Well, now, I'm really glad you asked that question because that actually comes to the crux of one of the problems that we face and why I think this committee might want to deal with this issue. I'm just a computer guy. I'm a law school dropout. I want to put all 50 state laws online. If you go to the official...
Well, let's stop right there.
Okay.
I have no problem there. The law itself. I think the problem we're getting into is the definition. That's why I said, what is an annotation? And if you go to the free public website, it took 3 clicks to get there on the Georgia legislative page, of which I was a member for 6 years. All you got to do is go, and you actually get the free Georgia code annotated, in which it says the annotated code is copyrighted, but it makes specific reference to say that the law or any other recognized by the law is not copyrighted. It's the work of the annotation which is more than the law.
But Congressman, the terms of use of that free site prohibit me from making a copy of that. It specifically prohibits all public and nonprofit.
Well, what it prohibits you from doing is taking a book and copying it and turning it in as your own work. And when I was in school, that was called cheating or plagiarism or however else you want to describe it. So, I mean, I think that, look, the questions that are coming here, the annotation part is really where we're getting here. And you make a claim, and I've read your book here, and you made a comment that says that states such as Georgia, Idaho, Mississippi, with all due respect, Idaho and Mississippi, I'm not as concerned with them right now, have spread fear, uncertainty, and doubt sufficient to throw a deep chill on their ardor. And that makes great prose. And you're a good author, and if you were the part of this, then you should have it protected.
Although this is, I actually...
But if you put it out to everybody, that's your choice. Okay? But you're not, and frankly, I believe you're being disingenuous here. To throw a deep chill when you can go 3 steps and get it for free? I think the part that I'm concerned about here is really, it's the bigger step of taking part of which we all recognize the law, okay? The statute is the gentleman from California made what we vote on, that code, that actual non-annotated, non-commented on. I mean, to say that an annotation is the law would be about like taking this committee memo and saying it is part of the federal code. That's just not true. It's written by someone else. It's input by someone else. So the question really comes, for me, is the way that it was handled. It's just taking it off. It's already free. The issue is there. We've already discussed that, but there's a part that is kind of because it actually was the work of someone else. You're right. We need to make sure that copyright laws, and as all these others have discussed, and the issues that there needs to be a proper balance. I just believe here in this issue, especially taking the state of Georgia and others and claiming that they're chilling innovation, they're chilling this, I think is over the top to make a point about something that is not really true. And that being that the law itself will not negotiate. That is part of the public record. But if I have somebody that if I've wrote my annotation and I've done the work, then we respect the work. We don't go out and say, well, I've got the book, let's copy it, send it up, just simply because I don't want to do the work of annotation. And I think that's the problem I have. And with that, we'll have many more conversations. I appreciate your work. I appreciate the rest of them being here. But I think that goes back to the heart of it here. If you do the work, the protection's there, not taking a shortcut because you just simply don't want to do the work. Mr. Chairman, I yield back.
I thank the gentleman from Georgia. The gentleman from New York, Mr. Nadler.
Thank you, Mr. Chairman. Let me start by thanking the witnesses for their testimony and the committee chair for bringing these issues before the committee, because I do believe that we have to do a better job of protecting content owners, artists, musicians, and creators, and making sure they're appropriately compensated for their work. But I want to ask more broadly about protecting copyright today. Professor Lunney, you mentioned there's no need to make explicit to make available right, and that it would not have an effect on curbing online theft. You mentioned that with BitTorrent users are uploading and downloading simultaneously and making thousands of illegal copies. The law has already made this practice illegal, but it has not stopped it, as we all know. Content owners have tried to chase their works across the Internet, which is not practical, not effective. We heard Chairman Goodlatte mention that Google has now received its 100 millionth takedown notice. And obviously someone observed that the Digital Millennium Copyright Act is broken. What would you suggest, without reprising soap or getting into that, as an alternative way to protect copyrighted works on the Internet? Is there any?
Well, I mean, a number of us in the Academy have explored the idea of having a levy, a levy would be a system where you authorize consumers to file share as much as they would like, and then you add a charge to their internet bill each month, and that money goes into a pot, and it's redistributed to the copyright owners whose works are being file shared. I am not certain there is any other solution that's going to...
Wait a minute, let me just explore that for a second.
Sure.
You set up an ASCAP type system, in effect, like as we do for songs.
Yes.
Where you can download it. Google doesn't get a takedown notice, but does note that you downloaded it. And you pay into, well, who pays into this fund? Anybody goes on the Internet?
It would basically be a surcharge added to your internet bill would be one approach.
I never listen to music, let's say.
This is one of the central concerns with the levy approach. It's unfair to people who do not file share. But it would be a mechanism for compensating authors and copyright owners for the file sharing that's going to go on.
So anyone who accesses the Internet would pay a levy, which would be administered by some new organization or old organization. And the funds would go based on someone's assessment of how many people listen to my song?
Well, how the funds would be distributed would have to be decided, but we could use some sort of sampling system similar to ASCAP or BMI, or the investigators that are currently tracking downloads in order to sort of bring actions to get a subpoena.
It's a very interesting. Let me ask Professor Nimmer. What's your reaction to this interesting suggestion?
My reaction,
besides saying that it's an interesting suggestion.
Well, in that case, you preempted my first sentence. I put in footnote 69 of my written statement the citation to Professor Netanel's article called "Impose a Non-Commercial Use Levy to Allow Free Peer-to-Peer File Sharing," and that's one of many solutions Professor Lunney himself has written on the issue. The problem with these proposals, they're feasibility problems, they're treaty compliance problems. So I do not wish to prejudge it at the outset. It's a fascinating vehicle. It requires a lot of study. The devil is in the details, as always. But it's a completely different way of looking at the issue, and it deserves to be investigated.
You said there are a number of others. Are there other major suggestions available?
Yes, I think...
Again, without getting into the whole mess we had with soap?
Professor Fisher at Harvard has propose something that I'll basically call an entertainment tax, or the government could decide how much money has been made through all the arts and allocate that and allow free sharing of culture. I'm almost lampooning his book-length proposal, but in essence, that's what it is.
Might be interesting if you take out the word tax. Professor, which has a certain ring around here. Professor Schultz, would you comment on any of this?
Yes, I think the levy idea is a terrible one.
You said what?
It's a terrible idea.
Okay, because?
You have the government, you're inviting the government to set prices, and a fundamental concept in copyright law, in any property right, is that the owner gets to decide the terms on which it's alienated. And when you take away that liberty, you take away, first of all, the value of the price signal. We no longer know.
And this, your comment now would apply to a private ASCAP type thing as well as to the...
No, not to a private ASCAP thing, because to a system like that, people enter it voluntarily.
What would your comment on that be?
So in a system like that, sure, there are plenty of collective rights organizations. When they're privately entered into, they solve a lot of problems, but it's essential they remain private. Otherwise, the government determines price.
Okay.
It harms
No. Yeah. Mr. Love or Professor Love wanted to comment.
I mean, we've had a long history of use of compulsory licenses where markets aren't really functioning very well, and often connected with new technology. So I don't think it's really beyond the pale that you move to some kind of a compulsory license. And then there's this, you have the twin issues. You touched on the issue of how you pay the money out. I think that the first instance people look at is the sort of sampling thing that Professor Lunney and others referred to in terms of distributing. A different approach is to have the consumers be able to pick the collection society that they think rewards the artist in the way that they prefer, so that in effect the consumer is in a way becoming kind of a patron of the arts, mandated to be a patron. But
you have several operations doing similar things, and the consumer chooses.
Yeah,
one.
You would pick. Like perhaps one would give all their money to Madonna and Britney Spears, and another one would sort of do it a little bit differently, and you would be able to pick the entity that you thought supported the art in the way that you preferred. That's called the Bird-Blanf model, which is a different model than the sort of sampling model. But there are these alternatives, and they're usually connected with some kind
These sound like things we ought to explore, but I see my time has expired. I thank you all.
I thank the gentleman from New York, the distinguished gentleman from Texas, Mr. Farenthold.
Thank you very much. And let me ask Professor Lunney, if we were to codify a make available right, what would it do that we can't do already?
Well, in the file sharing context, as I've said, I don't think it would change what's going on in that arena at all. If it makes it marginally easier to pursue file sharers, I don't think as a business decisions we're going to see a new round of mass.
Let me ask Professor Nimmer, other than making it easier for a plaintiff, what other protection are we going to provide creators?
I think the essence is to make it easier for the plaintiff and thereby to comply with the U.S.'s treaty obligations and to resolve the conflict in the case law.
So how many bad guy infringers are getting away now that wouldn't be getting away if we were to do this?
Obviously, I don't have the empirical figures with me.
Do you realistically think there are any?
Well, no one who's been sued or brought into the legal process has gotten out, as far as I'm aware, because a download could not be proven.
All right, and let's talk a little bit about make available. We talk about it in a traditional upload context. We say, all right, you put it in a shared folder, you've made it available. Well, have you made it available if you link to it? Say you're Google and you're a search engine and you haven't posted anything yourself, but you link to it. I mean, a broad definition of make available. Obviously, we could craft the statute however we want. I mean, you could potentially get, what I would consider non-guilty parties there. Professor Lunney?
Well, the worst part in my mind is we wouldn't know. If you adopt a broad general making available right, we wouldn't know until we litigated it whether linking would be infringing.
So would a broad make available right, if I took my copy of the latest Brad Thor novel I bought and read and donated it to the library, would I then be making that available? And have we completely undermined the first sale doctrine there?
In both the treaties and in the distribution context, and I think Professor Nimmer would agree with me, there is an exception where the making available right can still be limited by the first sale doctrine or exhaustion.
And what about making available on a less public basis? I have iTunes in my house, and there's a shared folder on there that I've made available to my television set and to my other computer, and probably my daughter's television set and my wife's computer. Where do you draw the lines within there?
Good. The danger in here is in a standalone make available right. If Congress were to pass a new seventh right under copyright, which is making available all the dangers that you've cited would face us. However, I believe we can avoid all those dangers, including the danger of sharing with your wife and daughter, if we simply define the copyright owner's public distribution right to include making available. When you include your wife and daughter, that's not an act of public distribution, so you don't need to worry about the making available.
I want to hit each of the topics here, so I need to go to Professor Schultz. I'm a former broadcaster, and I understand how tough it is for local broadcasters. But you look at something like is going on with the Irell case. Don't the broadcasters want as many eyes as possible viewing their newscasts so they have more value to sell to advertisers?
Oh, that's a good question. That advertising revenue is one component of how they make how they constitute their business. But there are other components, including the retransmission fees, that are essential to supporting local broadcasting.
And, so I guess the other issue then becomes, at what point do I have to negotiate a deal with all my local television stations to put a sling box at my house so I can watch the Corpus Christi newscast when I'm in Washington, D.C.?
You absolutely don't have to negotiate.
I just want to make sure it doesn't go that far. And then let me go down here to the other end of the table real quickly speaking, and I'm going to have to agree that once something is enacted in a law, the public ought to have a right to get to it free. Don't these standard-setting organizations, Ms. Green, collect membership dues and generate revenue from the members who participate? I mean, I understand in the old days it cost money to print up the books and distribute it, but now the marginal cost of making this information available over the internet is basically none, and there's zero value to some of these, to a light bulb that doesn't fit the light bulb standard, to use your analogy. Shouldn't the private sector that benefits from these pay for them, and the public should have them free? Why shouldn't I be able to print out a copy of the electric code to make sure the electrician hooked the green wire up to ground in my house?
Well, a couple of things. Thank you for the question. First, the SDOs have different business models. Many do base their revenues on membership fees, but many don't. And those that don't are largely not-for-profit, mission-generated organizations that keep their barriers to entry low. That is, they have low entry fees, they have low membership fees for the very reason that they can use the sales derived from the revenues derived from the sales of.
I see my time is expired. I would love to sit down with you, and we could probably debate this for an hour. And it's actually something I would like to do, because I do think it's important that I think you may waive your right to that once you fight to get it enacted into law, or it gets enacted into law. It's something we can talk about when we have more time. So, Mr. Chairman, I'll yield back.
I thank the gentleman. There'll be ample time for us to revisit this time and again, I'm sure. Mr. Johnson, the gentleman from Georgia.
Thank you, Mr. Chairman. Mr. Chairman, I started practicing law about, back in 1980, and then going into the law libraries, Georgia State University, to get ready for cases and to represent various folks in my general practice. I recall coming upon Mr. Nimmer's books, and I can't believe that he's sitting here looking as young as he looks. I thought he'd probably be about 90 years old by now. But thank you for your contribution, sir. And I've long supported strong copyright protections as the backbone of innovation, creativity, and public good. But materials created by the U.S. government and state governments do not deserve copyright protection, nor have they ever received it. In 1888, the Supreme Court held in Banks versus Manchester that there has always been a consensus that judicial opinions are in the public domain because the work of judges binds every citizen and is and should remain free for publication to all. Since then, courts have continuously upheld this understanding that the law, be it state or federal, is in the public domain. Section 105 of the Copyright Act reflects this view, specifically denying copyright protection to statutes and regulations. At its core, this issue touches on the American ideal for justice, that we must know the laws that govern us. This right is fundamental to the rule of law that underpins our democracy, particularly when that concept of ignorance is no excuse pervades our process. It is also central to upholding our system of checks and balances by holding Congress accountable for the legislation it passes or fails to pass. As we review copyright protection in anticipation of the next generation, the next great Copyright Act, we must continue to protect Americans' access to laws and justice by protecting access to public materials in the public domain. Mr. Malamud, and thank you for appearing here today before us. I want to take this moment to thank you for your work making public law accessible and known. It's easy to take for granted how important public databases are in our increasingly digital democracy. Unless public documents are digitized and available, they are often out of reach of many. In your written testimony, sir, you note that you are currently publishing official state and municipal codes. As a former commissioner in DeKalb County, Georgia, I appreciate the importance of private citizens working to improve local communities. What is the benefit of making bulk public data available for municipal governments? And I'll add to my comments the fact that when you want to, if you're a citizen of the state of Georgia and you want to go and look up a code for a local political subdivision, it's very nice to be able to go online and be able to get that information. But what is the benefit of making bulk public data available for municipal governments?
Thank you for your comments, Congressman Johnson. The issue we have with the Georgia Code as it currently is you cannot get the bulk data. You cannot go to the free website and download the whole thing and make it better. What happens when bulk data becomes available is volunteers, some commercial operations, but often simply citizens will go in and make the code significantly more accessible, work on modern platforms. This happened in the District of Columbia just recently, in which copyright was waived on the District of Columbia code. Several volunteers came in and they have developed a vastly better version of the DC code that informs citizens in a better way. So by having the bulk data available, we encourage citizen participation in the process of informing each other. And that's why we care so much about, for example, the official code of Georgia.
How have local governments responded to making municipal codes widely available?
We have had significant pushback at the state level. At the city level, they are welcoming us with open arms. The city of Chicago, I recently stood up with some former staff members from Congressman Issa, former Obama White House officials, both volunteers. We stood up with the city clerk of Chicago and unveiled a new Chicago code. San Francisco has recently revamped their municipal code. There are about 2,000 municipalities that are about to have better municipal codes available because of the efforts of these volunteers.
Thank you, and my time has expired, so I'll yield my remaining time back.
I thank the gentleman from Georgia. I am told, folks, that there will be an imminent House vote before imminent, whatever that means. And I hope we won't have to detain our witnesses. So with that in mind, I recognize the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Mr. Malamud, I'm assuming you agree with the Veek versus Southern Building Code case?
Absolutely.
Outcome of that. What about the two cases, the circuit cases that we have the amicus brief here in our stuff that were discussed involving one was the AMA codes and the other was the used car red book. And in those instances, the courts found that there were copyright protections. So what is your opinion on those cases? Do you agree with the outcome in those cases?
So I'm not a lawyer. I'm just a citizen. But my take on that is that the VEC decision was about a crucial public safety code that had been incorporated into the law, whereas the other cases were about like medical codes that needed to be used by doctors. And it to me was the distinguishing factor was the extent that the public safety was at stake. And also, if you look at the building codes, they all begin with a sample ordinance of incorporation. We, the people of insert name of jurisdiction here, do hereby adopt this code. So this was meant to be the law. And to me, that's the difference between those cases.
And so you think that it does, just the fact that government may have some type of administrative scheme or program that something is referenced, whether it's a red book or something, you do see the distinction between those situations and one in which the law is adopted verbatim from one of these publications?
When I post a public safety standard, I look for one that has been explicitly and specifically incorporated by reference, as opposed to casually. In fact, we look at state codes and often they'll mention something in passing and we keep our hands off those. But when it becomes part and parcel of the law, then to me, the fact that it happened to be an external document is no different than if the state had authored that themselves.
And Ms. Griffin, I guess, what is your position on Veek versus Southern Building Code? Do you think that was incorrect?
I think there's a sharper distinction to be drawn between VEC on the one hand and the two circuit court cases that I cited on the other. VEC was a very unique situation, and it was a case that was limited to very unusual facts. In that case, the model code writer wrote the code with the specific intent that it be incorporated word for word into the law. It was, in fact, incorporated word for word into the law, and the defendant in that case copied the law qua law and not the model code. Under those circumstances, the Fifth Circuit said that as the law, this content loses its copyright protection. But the court was quick to point out that it was a very limited case, that it did not apply to what they called extrinsic standards, that those are standards that are incorporated by reference into law, like the standards in the Second Circuit and Ninth Circuit cases. And so I think that makes VEC a very limited holding and limited to its facts. How that might be decided today, it's unclear to me.
Well, I know they use these model codes in different areas of the law. How often do they just adopt completely verbatim, like what happened in the VEC case, versus, I mean, obviously legislators can use some of these model codes as guidance. They don't have to adopt it all. I mean, that's more of a unique case you're saying when you're adopting everything wholesale?
Personally, I'm not my organization is not a standards developing organization, and I don't have statistics at hand as to how it works. I know that some code developers enter into cross-licensing agreements, for example, with the governmental entity, such that the code could be adopted, but there's a site in the regulation back to the standards developing organization's website for the sale of that. I think there are very different kinds and multiple opportunities for dealing with that situation. And I think that's one reason why NARA has said, in the context of its recent evaluation of this, let's leave this to the federal regulators and the SDOs to come up with a way to make access reasonable. Because at the end of the day, it's about access. And it's about whether the public has access to the standards, not how much they cost, or if they cost something, but if they have access.
May I add very briefly, when the VEC decision was appealed to the Supreme Court, the Solicitor General came in and suggested that the VEC decision was good law and that the Supreme Court should deny cert, and the Supreme Court followed the Solicitor General's recommendation.
Right. So, Ms. Griffin, just in terms of as these standard and codes are developed by different associations or whoever is involved with that, I guess what is the risk for the viability of that without copyright protection?
Oh, it's a huge risk to the standards developing organization if they were not permitted to derive revenues from the sales of standards, then they would not be able to fund operations. And those operations include, as I said earlier, providing the administrative support for the development of standards to ensure that all reasonably and materially interested parties are sitting at the table, to make sure the consumers are at the table. No one will pay for that, but the standard developing organizations who are mission-related and not-for-profit organizations. And they're able to do that how? By selling the standards and using the revenues. If, by contrast, the government was to take that process away, the government would have to provide that expertise, the government would have to provide that administrative support, and ultimately the taxpayers would pay for that. So I think it would, the change would result in a very profound and detrimental change to the way that standards are developed in this country.
Thank you. I think my time has expired, and I will yield back.
I thank the gentleman, the distinguished lady from California, Ms. Lofgren.
Thank you, Mr. Chairman. I'll be brief because I want to make sure that my colleague, Ms. Jackson-Lee, also has an opportunity to participate. You know, as I have listened to some of these proposals, it seems to me kind of interesting that people seem to have forgotten our experience with SOPA just a year ago. I don't think, and I mean, if someone feels differently, please speak up, that the American public's attitude towards SOPA has done a U-turn in the year, you know, that's happened since then. And the idea of the performance make available proposal really just goes in the same direction we were going there. That's a non-starter in my opinion. I certainly value getting viewpoints and academic discussion, but it's not going to happen. I think one of the things that has been raised that we should review is the issue of statutory damages. And when you take a look at some of the really outrageous things that have happened with statutory damages, I think of the case of the single mother. The RIAA brought a case where a jury awarded $1.5 million against this woman for downloading 24 songs with no indication that she had ever even shared them, as a matter of fact. Now, that was reduced to $54,000 because of the disproportionate nature of the statutory by the judge. But that you have that kind of statutory scheme is irrational. And it needs to be changed. And I think back also, the orphan works discussion, you know, I spent a long time trying to work on that and finally gave up, along with the other members of the committee, because of the intransigence of some of the participants. But I think one of the things we ought to take a look at, you know, is what the damage that we did by extending the term, the copyright term. We now have a copyright term that basically is a century and a half. And we've aggravated the issue of orphan works by doing so. Unfortunately, you know, you wish you could go back in time and undo some votes, and that's one. I was convinced I think I was a freshman, that the WIPO treaty required that vote, and I now know that that was not the case. I wish I could undo my yes vote on the Sonny Bono Copyright Extension Act. Finally, I think the real value of this hearing is the issue raised about standards and public law. I was going to ask unanimous consent to put into the record the standard test methods for lead and water. I don't need to do that because my colleague, Mr. Isa, has already done so. But it seems to me very clear that you cannot have secret law. If you're going to require people to adhere to a standard, that has to be in the public domain. And I'm sympathetic. I understand there's a business model set up, but you can't allow the business model to trump the rule of law. And I'm mindful of the discussion that we had about publicly funded research. And we had a hearing here a couple of years ago, and the nonprofit societies are basically funded by for their peer review process, which is essential. by the publisher. And yet, and that's a business model that actually was deleterious to the public's right to have publicly funded research made available publicly. We've now changed that, and I think over time, the way we fund nonprofit science societies is going to have to follow along and change as well, because they do provide a useful model. But you can't allow that current business model to dictate the end result, which is if you incorporate by reference a document, that has to be part of the public record. And if there's a fee, for example, I mean, that assumes that the public doesn't have an interest. If I'm a contractor, you know, maybe I can afford to pay the fee because I'm going to make money after, you know, on that. But there's a public interest in this. It's not just the people in the business. It's the public's right to know. Is this a sufficient standard? Well, the only way you're going to find out is to have free access to it. And to put up a screen to that if it's part of the law is completely, wholly inappropriate. I agree with Mr. Issa that there's no copyright reform that we should support that doesn't resolve this issue. And I've listened with great interest. As I say, I think although there's academic interest in this, certainly the public spoke very loudly about SOPA, and I don't believe that we are going to have the appetite to revisit that either in our copyright laws or, frankly, in the TPP negotiations that are underway. You're right, we don't know what they're negotiating, but the leaks to WikiLeaks are SOPA. And if SOPA is in TPP, it's dead, in my judgment. With that, I see my time has expired, and I yield back.
I thank the gentlelady. The gentlelady from Texas was Jackson Lee.
Let me thank the chairman and the ranking member for the generosity of time, and I want to associate myself with my colleagues. This is an excellent panel and well committed in this area and with a lot of history in this area as well. Not enough time for our questions. I just want to go across to everyone. I know that you spoke to different issues, and my colleague mentioned SOFA. Just want to get in this question a yes or no. Do you feel that Congress should wade into your particular issue of testimony today? Dr. Nimmer, Mr. Nimmer?
Yes.
Professor Lunney?
No.
Professor Schultz?
Not yet.
Mr. Love?
You should pay attention to the WIPO negotiation on the broadcast treaty.
Is that yes or no?
Well,
I just
should you legislate? Should you change U.S. law in that area?
Yes or no?
We don't even know what the treaty is yet. It's a mess, right?
Thank you, Ms. Griffin.
No, in the sense that's been suggested by Mr. Malamud.
Absolutely, yes.
Thank you very much, Professor Nimmer, now of Counsel, but I'll always call you Professor. In your testimony, you note a scenario where a P2P user who goes to trial is helped somewhat by the fact that a judge would feel that an award disproportionate with actual damages would be inappropriate and thus might be inclined to not construe the making available right in accord with their actual feelings about the law. Could you please elaborate on this? And I do have one or two other questions, so I'm going to go quickly. And what would be a just recalculation of the statutory damages so that Jamie Thomas Rassett does not face a multi-billion-dollar judgment? And I want to ask Professor Lunney, could you expound on your view of the broken window parable presented in Frederick Bastiat's parable in English, that which is seen and that which is unseen, if you can think of that. And I do want Professor Schultz, I know that my colleague from Texas asked about Irell, but if you could just expand on it just a little bit. Professor Nimmer?
Yes, when Jamie Thomas Rassett went to trial, as has been noted, the award against her was at $1.5 million. She had the option of settling. The plaintiffs offered her a settlement that she could pay several $1,000s to a charity designed for musicians, and she turned it down because she had committed perjury and because the trial was so egregious, the jury came and hammered her. But the question now, as I understand it, is what should be a reasonable measure of statutory damages. And it did make sense back in 1999 when Congress calibrated statutory damages to look at how many works had been infringed, because at that point in time it was not possible to infringe 100 or 10,000 works, which just was physically impossible. Today with peer-to-peer, it is possible. And so Congress needs to look at what level of damage would cause deterrence and would compensate and would be somewhat related to the harm. So I did not come here with a ready metric, but it could be several hundred dollars for each and every copyrighted work that was implicated, or it could be $100,000 in any given lawsuit that's brought, or another measure that's somewhere within reason and does not get us to the hundreds of millions of dollars.
Thank you. Some criteria. So refinement, clarity, and determining how someone could be made whole. Professor Lunney, on your question, please.
Thank you for the question. So Frederick Bastiat, writing in 1850, was explaining that when the government creates a subsidy program for the arts, that's not new money in the economy. They're taking that money from consumers through taxes. They're giving it to the arts. There's going to be new employment in the arts. That's what we see. What we don't see is that by taking the money from the consumers here through taxes, those consumers won't have that money. They can't spend it on something else. And so the jobs that are lost in those other sectors because consumers no longer have the money to spend in those other sectors is not seen, and we tend to ignore it. But we shouldn't. If you're just moving money in the economy from one jar to another, creating jobs here, losing them there, there's no net gain for the economy. So if we could come up with a magic formula, wave our wand and solve file sharing and restore to the music industry some of the money that's lost, perhaps as a result of file sharing, that would not be a net gain in jobs for the economy. We would simply be forcing consumers to pay more for music. They would have less money to pay for everything else, and so whatever jobs we gained from that revenue in the music industry, we would lose elsewhere in the American economy.
That is, let me just let Professor Schultz go on the Irell. Thank you very much, Professor Lunney. Professor Schultz, just a little bit more expansion on the Irell case.
Absolutely. So in Irell, you have a company, a single company, distributing a TV signal to many customers. That would seem to fit the definition of a public performance. However, Irell, through what they perceive is I would suppose it's a loophole in copyright law, are using really antiquated technology, building an array of antennas for each of their users and distributing the signal. And they're not paying copyright royalties. They're not paying retransmission fees. And you have to ask yourself, as between the broadcasters and the creators versus Irell, who has the moral and economic right to distribute those signals and profit from them? And I hope the Supreme Court rejects the interpretation of the law that allows Irell to do this, but if they don't, I hope this Congress will address that.
Mr. Chairman, you have been gracious in your time. I think there are a lot of competing issues here. I think we have a great respect for our artists, a great respect for broadcasters, and a great respect for the posture that Professor Nimmer has taken and many of you have taken. And so I thank you and look forward to more hearings on these important issues. I yield back my time.
I thank the gentlelady from Texas. Mr. Conyers and I and other members want to express our thanks to the witnesses who have prevailed during this marathon today, but it's been a very worthwhile, balanced presentation, it seems to me. And as I said at the outset, I appreciate those in the audience who have remained in its entirety. Your presence indicates more than a casual interest in this very, very significant issue. This concludes today's hearing. Thanks to all of our witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This hearing stands adjourned.